Yes.
My lord, number 8. 8 matter.
Yes, sir. My lord, 8. So my lord, I took the consent, they are the appealant. Test by petition. So maybe allowed 16th of December because my client is about India. So he'll come back on 10th of December. We file. In the meantime, we have ready the objection. In the meantime, we file.
The intent may be extended, madam.
Mr. R.C. Paul, learned counsel for the respondent number 26, adjournment in this matter on the ground that his client is out of the country and therefore the respondent could not file affidavit. First up, the prayer is not opposed by Mr. V.K. Borua, learned counsel for the petitioner. First up, the petitioner's counsel has, however, requested for extending the interim order. First up, in view of the above, this matter stands adjourned for 2 weeks. Interim order passed earlier to continue.
Matthew.
May I be lordship? Lordship, I'm praying for listing 2 matter lordship. One is a RSA is a 2014 matter lordship, the heading matter lordship, and another is a CRP lordship is a 2019 matter. So by Monday, if possible lordship.
Wednesday.
Wait, yes, lordship. I understand.
May I appeal, Lordship? Lordship, with the concern about the other side, I beg to mention item number 7, Lordship. Kindly this matter will be adjourned for the day, Lordship.
Lordship, I am for the appellant side. Lordship, there is an urgency in this matter. That may be fixed, Lordship. It's related to pensionary, some pensionary benefit. Lordship.
Pensionary benefit.
Yes,
This
we
is
have.
a testamentary appeal.
Yes, Lordship, we have challenged the succession certificate.
When do you want it?
Next week, any date. Lordship.
Next week, not possible. After that.
Okay, after 2 weeks, then any date. Lordship.
Your name, please.
Lordship.
Mr. R.S. Rohan, learned counsel for the respondent, seeks adjournment in this case with a request to post the matter for hearing after 10 days. System. Mr. Your name, please.
N. Rai, Lordship.
Mr. N. Rai,
Yes, Lordship.
learned counsel is present on behalf of the petitioner, on behalf of the appellant, and seeks posting of this matter again on 15th of November. Prayer allowed. Registry to list the case accordingly.
God bless you.
May beg your lordship, item number 1.
Item number 1.
Yes, lordship.
Yes.
Actually, my senior had to move to Borpeta due to one of his family member has been hospitalized. Next week, maybe matter may be fixed. lordship.
On the prayer of petitioner's counsel, this matter stands adjourned for a week. Yes. Yes.
God bless.
My lord, this is a judgment of reversal, my lord. My lord, here in this case, I have formulated the draft substantial question of law. Whether the learned lower appellate court erred in law in dismissing the suit of the plaintiffs by reversing the judgment of the trial court by holding that brothers of late Nasir Ali are the sharer by misconstruing the provision of Mohammedan law, though Nasir Ali died leaving behind
What is the meaning of sharer?
brothers will be the residuary,
No, what sharer means what? Shareholders.
shareholders. But whether
Shareholders, not shareholders. Number 3 is a question of fact.
Number 3, my lord, whether learned lower appellate dismissing the suit of the plaintiff by reversing the judgment of the trial court by holding that Samsun Nessa exhausted her share for determination of this, my lord, share is to be determined, how much share each of the sharer got.
Yes, but
Without-
these are this question of law. How much share X is in a property
Yes.
is a question of law.
No, but without determining the same, this point has been decided. Without determining the same, this point has been said that she has exhausted her share before selling it land to the plaintiff. Plaintiffs.
So you are basically putting the same question in 4 different formats. It is the same question.
No, two is different, my lord. Two and four.
Take down, heard Mr. S.K. Ghosh, learned counsel for the appellant. Admit the appeal. Call for the records, issue notice returnable in 6 weeks. Appellant to take steps for service of notice upon the respondents by registered post with AD. This second appeal will be heard on the following substantial questions of law. First, in the absence of determination of the shares, in the absence of proper determination of the share as well as right title and interest of the brothers of Nisar Ali, whether the learned lower appellate court was justified in law in reversing the judgment and decree passed by the trial court and dismissing the suit. Full stop. Question mark. Number 2. Whether the learned lower appellate court was justified in dismissing the suit filed by the plaintiff for non-joinder of necessary party without granting an opportunity to include such party to the suit. Full stop. Question mark. Whether the judgment and decree of reversal passed by the lower appellate court is perverse in the eye of law. Question mark.
Much.
For order of item 3.
Delay of 784 days.
84 days.
What is the explanation? Let us see.
Philosophically, say paragraph 5, 6.
Hmm. This delay of 784 days is on what count?
Because I have no knowledge.
No, delay in filing the second appeal.
Second, no,
Then
this substitution petition.
Achha,
My mother is the only applicant. She expired.
Already filed the objection, man.
I limited objection is something to the point.
you are not audible. What is this happening? Hmm. Yes.
My only objection is only on the point that their file is.
1 minute. Is it on or off? Volume?
They have
Yeah,
filed
thanks.
this application after the.
Yeah, they have.
Have you filed your objection? It is not on record. When did you file?
First of November.
It's not on record.
I paid this measurement government Monday, man.
I have the copy.
No, that will, we'll need it here. Heard Mr. J. Hamel, learned counsel for the applicant. Also heard Mr. P. Bharadwaj, learned counsel appearing for the opposite party who submits that objection filed on behalf of his client on 1/11/2022 is not on record. Mr. Register to verify, trace out the objection filed in this IA and list the matter again after a week. Yes, Mr. Chaudhary.
Yes, madam. May please. Madam, in this case, against the money decree, madam, the RSA has been filed, madam, it is admitted. Only point involved in this case, madam, that whether the work order of the work order issued to the respondent, that was as per procedure by under the laid down under the municipal act or not. If it is not, madam, it is not binding upon the municipal board for payment of the sum, madam. Section 64, madam.
All right, let us see what are the substantial
Sir.
questions on that. Yes.
But before going to the judgment, my lord, I am showing the provision, my lord, because only I am reading section 64, my lord. Execution of contract, the board may enter into and perform any contract necessary for the purpose of this act. Every contract made by or on behalf of the municipal board in respect of any sum exceeding 500 rupees or which shall involve a value exceeding 500 rupees shall be sanctioned by the board at a meeting and shall be in writing and signed by at least 2 of the members, one of whom shall be the chairman or vice chairman, and shall be sealed with the common seal of the board. Unless so executed, such contract shall not be binding on the board. So this stand has been taken in the written statement by the chairman, my lord. Work order issued, my lord, that was not. No sanction was there from the municipal board. In the evidence it is there, my lord. So in spite of that, my lord, the decree has been made by the trial court and that has been affirmed by the appellate court also. So
Let us read the judgment of the
Ye-
first appellate.
yes.
court.
The lordship will find the appellate court judgment at the page 31.
1-3. 1-3.
30, my lord.
Yes, please.
From starting, I am reading. The
Yes.
judgment and decree dated 11/9/2012 passed by the learned Munsif number 2 Nalbari in MS case number 35 of 2010 are the subject matter under challenge in the present civil first appeal. On Appraisement of the original case record, it appears so that the plaintiff has filed a suit for recovery of an amount of rupees 83,340 only. The case of the plaintiff is that as per the order of the chairman Nalbari Municipal Board by letters when sued dated to 21/6/2008, the plaintiff was allotted the work of supplying of materials for the construction of Pakka drain along Kola Pukitula Road at ward numbers 5 Nalbari. The following item and quantity were allotted to the plaintiff for supply. First class brick, first class broken brick, cement, quarry, and sand and stone egg. The plaintiff duly executed the said work, and after completion of the supply work, submitted the bill to the defendant for payment on 23/7/2008, and the bill was approved and passed for payment of the administrator of Nalbari Municipal Board. The plaintiff sent a letter dated 2/9/2009 to the administrator of Nalbari Municipal Board requesting him to make payment of the bill dated 23/7/2008. The plaintiff again sent a letter dated 21/4/2010 to the chairman Nalbari Municipal Board requesting payment of the bill amount. But no payment was made by the authority. The plaintiff also served a notice under section 326 of the Assam Municipal Act 1956 dated 4/10/2010 through his advocate, which was received by the defendant on 5/10/2010, but the defendant did not pay the bill amount to the plaintiff. The plaintiff has stated that he is entitled to pay interest at the rate of rupees 9% per annum, which effect from 23/7/2008 on the amount due. Hence, the plaintiff has filed the instant suit claiming rupees 68,600 only as principal amount, plus rupees 14,740 only as interest, total being 83,340 only with future interest, the rate of 6% per annum till realization, and the plaintiff claimed that accordingly. The defendant has submitted written statement and denied the claim of the plaintiff. The defendant has contended that there is no cause of action for the suit. The suit is liable to be dismissed for non-tender of necessary parties of the state of Assam and the Deputy Commissioner Nalbari being chairman of District Urban Development Agency and necessary parties in the suit. The defendant has stated that in respect of all contract works, the board is to take decision in the meeting of the board, and there should be publication of tender notice to ensure participation of the intending contractors and to choose proper person to execute the work at a reasonable rate. But there was no publication, no tender notice as regards the alleged work carried by the plaintiff, and the plaintiff executed the work at his own risk. The board does not have its own fund to carry out the said work, but it is the work to be performed by the board from the fund provided under the scheme Sarna's Jayanti Sohar Rozgar Yojana by the government of Assam. The fund is allocated by the District Urban Development Agency after due consideration of the scheme proposed before it. The Deputy Commissioner Nalbari is the chairman of the DUDA. The work carried out by the plaintiff did not have sanction and administrative approval of the DUDA. Since there was no administrative approval for the said work, there was no decision of the board for calling for the tender for the said work, and no tender notice was also published. The plaintiff, knowing fully well about not having administrative approval, executed the work at his own risk. In this case, there was no contract agreement executed or final work order issued. The board, without the sanction and administrative approval of DUDA, cannot have fund from DUDA. The defendant has stated that the plaintiff, knowing fully well that there was no administrative approval for the work and no sanction of money in respect of the work, inasmuch as there is no decision of the board for the tender of the said work carried out, the said work at his own risk, and that is why he did not go for the execution of the contract agreement for the said work. Therefore, the suit is not maintainable against the board. The claim of interest for delayed payment is not entitled, since the board has not been provided with the fund by the DUDA, and without the fund being provided for the said work by the DUDA, the board is not liable to pay any amount to the plaintiff. Hence, this suit, without the presence of DUDA, the government of Assam and the Deputy Commissioner Nalbari, is not maintainable and liable to be dismissed. Hence, the defendant has paid for dismissal of the suit. there were 6 issues were framed, my lord, whether this suit is maintainable, whether there is cause of action of the suit, whether the suit is bad for non-joinder of necessary parties, whether the chairman non-Bali municipal board filed his order number so and so dated 21/6/2008 allotted to the plaintiff the work of supplying materials for construction of Pakka drain along Kolapukitola Road at Ward number 5, Nalbari. Whether the plaintiff is entitled to the decree as paid for, to what reliefs the parties are entitled. Both the parties have reduced evidence to prove their respective cases. Learned trial court, after going through the evidence on record and hearing submission put forward by the learned counsel for both the parties, decreed the suit of the plaintiff. Being highly aggrieved and dissatisfied while the suit was decreed in favor of the plaintiff, the defendant, as appellant, preferred the instant appeal on the following grounds: that the impugned judgment and decree suffers from error in appreciation of material facts as well as this, and the same is not sustainable under the law and liable to be set aside. That while deciding issue number 3, learned trial court has committed illegality in not appreciating the ability of the defendant to pay the bill amount, as the authority to sanction the amount for providing fund is not defended, but the district urban development agency and the deputy commissioner Nalbari being chairman is necessary party along with the state of Assam, as fund comes from the state budget. That there was no tender in respect of the works allotted in favor of the plaintiff, and this was because no decision was taken by the defendant for execution of the work without availability of fund, which comes to the board and administrative approval and sanction by the DUDA. The board is handicapped in making payment without the fund being sanctioned, and this aspect of the evidence ought to have been considered in deciding the suit. That the learned trial court failed to consider the fact that non-execution of agreement between the plaintiff and the defendant in support of the work order was due to no sanction of the board, and the issuance of the work order personally by the outgoing chairman was in the personal capacity of the chairman, as without the board's decision, the chairman cannot issue such a work order. And this is evident that the plaintiff had taken risks to execute the work in spite of not having the agreement being executed, and there was no sanction of the work by the DUDA. And the evidence in support of this fact, in spite of being uncontroverted, the learned trial court failed to appreciate the laws regarding arrestable by conduct of the plaintiff in executing the work, knowing fully well about no sanction, no availability of fund. The municipal board functions under the Municipal Act, and violation of municipal laws by its chairman towards ensuring any liability owing to any illegalities done by the chairman, the liabilities arising out of such illegal action of the chairman, the municipal board cannot be responsible to meet up the liability against in respect of implementation of a scheme of DUDA. Accordingly, the findings of the learned trial court, by ignoring the evidences that the work order is not on the basis of any resolution of the board, as well as without administrative approval from DUDA, is illegal, and decree passed without consideration of this. And in absence of the chairman DUDA, the deputy commissioner Nalbari and the state of Assam is an inexecutable decree, as the municipal board is barely an agent for the execution of the scheme of DUDA. The findings of learned trial court in ignoring interest on the suit amount is based on no evidence and is perverse and contrary to the provisions laid down under section 34 of CPC. The learned trial court has no jurisdiction and power to grant interest on the amount of interest accrued on the decreed principal amount, which amounts to decreasing compound interest. On the above grounds, the appellant has prayed for setting aside the impugned judgment and decree. I have heard learned counsel for both the parties and gone through the evidences on record, and also perused the memo of appeal as well as the impugned judgment and decree. Decisions and reasons thereof. It appears from the argument put forward by learned counsel for the appellant as well as from the memo of appeal that the vital issue to be determined in the present appeal is issue number 1 and 3. Issue number 3 is contingent upon the question as to whether the suit is bad for non-joinder of necessary parties. Learned trial court decided this issue in negative and in favor of the plaintiff. Learned trial court took up the issue number 3 for discussion and decision along the issue number 1. Issue number 1 is contingent upon the question as to whether the suit is maintainable. The defendant has stated that the suit is not maintainable against the board alone in absence of District Urban Development Rural Agency of the Government of Assam and the Deputy Commissioner Nalbari being the chairman of DUDA. The contention of the defendant is that the board doesn't have its own fund to carry out the work without the fund being allocated by the DUDA. The work carried out by the plaintiff did not have sanctioned an administrative approval of the DUDA, and since there was no administrative approval for the said work, there was no decision of the board for calling for tender for the said work, and no tender notice was also published. The board without sanction and administrative approval of DUDA cannot have the funds from DUDA. The defendant has examined Chairman Nalbari Municipal Board as DW1 in support of the contentions of the defendant. DW1 has adduced evidence substantiating the averments made in the written statement. The defendant has not exhibited any document in the suit. There is no document produced by the defendant that the work carried out by the plaintiff did not have sanction and administrative approval of the DUDA. Well, if it is stated that there is no sanction, then how the documents will be there in support of that? Thus, there is no evidence adduced by the defendant to show that the work carried out by the plaintiff requires sanction and administrative approval of the DUDA, and that without the sanction and sanction order and administrative approval of DUDA, the Chairman Nalbari Municipal Board issued the work order. Under the circumstances, the defendant who issued the work order is solely responsible for payment of the money to the plaintiff for the work carried out by him pursuant to the order. In the suit, the plaintiff claimed the relief against the defendant. The defendant also has failed to show anything that the defendant is not responsible for payment of money. Therefore, it appears that DUDA, Government of Assam, and DC Nalbari are not necessary parties in the suit, as they are not parties without whom no effective decree could be passed. The defendant must produce rules and regulations to substantiate the contention of the defendant. Merely stating that the order was issuing without sanction of administrative approval of the DUDA, and that the board has not yet provided with any fund by DUDA, and without the fund being provided for the said work by the DUDA, the board is not liable to pay any amount to the plaintiff is not sufficed to prove the said contention of the defendant. In view of the above discussions, it appears that the DUDA, Government of Assam, and DC Nalbari are not necessary party in the suit, and as such, question of non-maintainability of the suit due to then not being made parties doesn't arise. Hence, the findings of the learned trial court in issue number 1 and 3 warrants no interference, and the same is upheld. Situated thus, the issue number 1 is decided in affirmative and in favor of the plaintiff, and the issue number 3 is decided in the negative in favor of the plaintiff. Issue number 4 is resolved upon the question as to whether Chairman Nalbari Municipal Board, by his order so and so dated 21/6/2008, allotted to the plaintiff the work of supplying materials for construction of Pakka drain along Kolapukitola Road at ward number 5, Nalbari. Learned court decided that this issue in affirmative in favor of the plaintiff. The plaintiff has exhibited the work order Exhibit 1. It is found from the Exhibit 1 that Chairman Nalbari Municipal Board issued the work order as claimed by the plaintiff. The defendant has also not denied in written statement the fact of issuance of a work order. The claim of the defendant is that the work order was issued without following proper rule, but there is nothing produced before the court by the defendant to show that the work order was issued without following the proper rule. The proper rule, the statutory provision is there under Municipal Act. It was shown, but it has not been reflected in the judgment. DW1 Chairman of Nalbari Municipal Board admitted in his cross-examination that the work order was issued to the plaintiff, and as per work order, the plaintiff has supplied the materials. It also appears from Exhibit 2, the bill submitted by the plaintiff, that the materials supplied by the plaintiff were duly received by the authority. PW2 Assistant Engineer of the Nalbari Municipal Board deposed in his evidence that he had given as note Exhibit 2 that the materials were supplied and received. PW2 exhibited the said note in Exhibit 2 as Exhibit 2.2. The signature of PW2 was exhibited as Exhibit 2.3. It is found from Exhibit 2 to note that the PW2 had stated in the note that the materials supplied by the plaintiff were received in full and the materials were utilized for construction of Paka drain along Kolapukutula Road at ward number 5. The rates given in the bill are also accepted as per approved rate of the municipality. The bill was also approved and passed by the administrator Nalbari Municipal Board as evident from Exhibit 2.4 and 2.5, Exhibit 2.5. In view of the discussions, it appears the plaintiff has proved that the chairman Nalbari Municipal Board filed his orders and so dated 21/6/2008 allotted to the plaintiff the work of supplying materials for construction of Pakka drain along Kolapukutula Road at ward number 5 Nalbari. Therefore, the finding of learned trial court in issue number 4 warrants no interference, and the same are upheld. Situated thus, the issue number 4 is decided in affirmative and in favor of the plaintiff. Issue number 2 relating to cause of action of the suit. The learned trial court decided this issue affirmative, issue in affirmative and in favor of the plaintiff. On appreciation of materials on record, I find nothing to disturb the findings of the learned trial court in issue number 2. Situated thus, issue number 2 is decided in affirmative in favor of the plaintiff. Issue number 5 and 6 are relating to relief claimed by the parties. In view of the above discussions, it appears that the defendant has issued work order duly to the plaintiff, and pursuant to said work order, the plaintiff also supplied materials as per approved that of the municipal board. The DW1 has admitted in cross that the plaintiff is not paid money for the work performed by him till date. Therefore, it is decided that the plaintiff is entitled to get the relief as paid for. Learned counsel for the appellant has submitted that the findings of the learned trial court in granting interest on the suit amount is based on no evidence and is perverse and contrary to the provisions of section 34 of the Code of Civil Procedure. The learned trial court has no jurisdiction and power to grant interest on amount of interest accrued on the decreed principal amount, and which amounts to decreasing compound interest. It appears that the learned trial court held that the plaintiff is entitled to a decree for recovery of the bill amount dated 23/7/2008 of rupees 68,000, along with an interest at the rate of 8% per annum from 1 month after the date of submission of the bill to the defendant side, and the plaintiff is also entitled to be paid an interest of 6% per annum on the bill amount, and its interest accrued from the date of filing of the suit till realization of the entire amount. It appears that under the provision of section 34 CPC, where and insofar a decree is for the payment of money, the court may in the decree order interest as such that as the court deems reasonable to be paid on the principal sum adjudged from the date of the suit to the date of the decree, in addition to any interest adjudged on such principal sum for any period prior to the institution of the suit. The further interest at such rate not exceeding 6% per annum as the court deems reasonable on such principal sum from the date of the decree to the date of payment or to such earlier date as the court think fit. It has further been stated in the said section that provided that where the liability in relation to the sum to so adjust had arisen out of commercial transaction, the rate of such further interest may be exceeded 6% per annum, but shall not exceed the contractual rate of interest, or where there is no contractual rate, the rate which monies are lent or advanced by nationalized bank in relation to commercial transaction, thus form the provisions of section 34 CPC. It is clear that court may grant interest on the principal sum only. Hence, learned counsel for the appellant has rightly submitted that the learned trial court has no jurisdiction and power to grant interest on the amount of interest accrued on the decreed principal amount. Situated thus, it appears that relief granted to the plaintiff in this suit require interference and modification. Accordingly, the relief granted to the plaintiff by the trial court is modified, and it is ordered that the plaintiff is entitled to a decree for recovery of 68,000 with interest of 6% per annum from the date of submitting bill till realization of the entire decretal amount. In the result, appeal is allowed partly on contest without cost. The suit of the plaintiff is decreed recovery of 68,000 with the rate of interest of 6% per annum from the date of submitting the bill till realization of the decretal amount. In this case, my lord, the only point involves whatever stated in the section 64 of the municipal act, my lord. In the evidence, it is clear, and in the appellate court judgment also it is discussed regarding evidence of the chairman. So far, the work order issued by the outgoing chairman on his personal capacity, he issued that without the approval of the board as required under section 64 of the municipal Assam Municipal Act. So the amount is, although court has decreed, it is not binding upon the municipal board. Even decrease, my lord, to that extent, my lord, sections in respect of section 64, my lord, it is.
So, Mr. Chaudhary.
Yes.
Is the appellant denying the fact that he has supplied these materials?
No, my lord.
That is not in denial.
No.
He has supplied.
Supplied, my lord. The materials were received, the evidence is clear, my lord. We are not on that point, my lord. But the municipal board, there is procedure, statutory procedure laid down under section 64 of this Assam Municipal Act. That
So basically your only ground is
yes, my lord,
64 is not complied.
not complied.
That is
So
the only ground.
64 says that unless so executed in accordance with section 64, the contract shall not be binding on the board. If it is not binding on the board, the board is not liable to pay the amount. That
Even if the work is done, what happens to the plaintiff? He has bona fide executed the work.
he executed the work, but there was no tender notice, no work order, no contract agreement, nothing else.
So it is a misconduct on the part of the chairman.
Yes, my lord.
What action the board has taken against him?
Board has not taken, only filed the suit, my lord. And that chairman is also no more in this world. So only on principle, my lord, this appeal has been filed. Because the amount is also not so much, my lord. But on the principle, my lord, if it is violated in this way in future, my lord, this will remain as a precedent for the municipal board, my lord. In respect of other cases also, at the whims and caprice of the chairman, no order will be issued and no contract agreement will be
That's all
done.
right, but if the chairman does things which are not in accordance with law,
Yes, ma'am.
then the municipal board ought to have taken action against him.
Certainly, my lord, but
That has not been done.
admittedly, it was not allowed.
Then why penalize this poor fellow? You see,
Only
in those days, today, the situation has changed.
yes, ma'am.
In those days, the small time businessmen, they would not go so deep into whether the chairman had the power, whether the.
From that angle, my lord, your lordship is correct.
But, there is another angle. Can you give me the contract act? There is another angle which he may not be
under the
arguing. Huh?
under the contract act. Yes.
You please see section 70.
Yes.
Do you have the contract act? I'll give you.
Okay.
You also don't have the contract act. Do you have it?
I have given.
Section 70. Ma'am. Obligation of persons enjoying benefit of non-gratuitous act. Where a person lawfully does anything for another person or derives anything to him, not intending to do so gratuitously, and such other person enjoys the benefit thereof, the latter is bound to make compensation to the former in respect of or to restore the things so done or delivered. Lawfully does anything to another person. Where a person lawfully does anything.
Yes. He did not do anything unlawfully. Lawfully does means while execution of the work.
So far the contractor is concerned.
Yes. Did he do anything unlawful?
No, my lord, that has not been reflected in evidence, my lord.
Then.
He supplied it, is admitted, my lord. We have not denied.
So you have to either give him back all these materials.
Yes, my lord.
Or you have to compensate.
Under section 70.
What is the other way out?
So if we are to compensate, then we will have to carry out the decree
That's correct. Because
under section
it
70.
is not his fault.
Yes. Only on principle, my lord, it has been filed, my lord, because section 64 of Assam Municipal Act, that was not complied with by the chairman.
That's correct. So that is assuming that the court accepts this argument in toto without
sir.
going into further detail. Then also here the defaulter is the chairman, then chairman, not the contractor.
Not contractor.
It is not his duty to have a board meeting held and get it passed. That's not his duty.
Yes.
He will go by the order of the chairman
I have understood you.
and would presume, otherwise it will have a disastrous consequence.
Yes.
How are these small-time business people going to survive? If they get a contract order, they will have to engage a lawyer and go into the who has floated this, who has given the sanction, who has given the approval. Can these people survive? Therefore, even if there is a legal issue, the court has to be conscious of the.
Contrary to that also, my lord, there are other decisions also in respect of the large contract, my lord. If tender notice is not there, there is illegal.
That is true in public case of public largesse.
Public.
But then the board doesn't find anything wrong with the act of the chairman. The chairman.
No action was taken.
If the chairman was right, then how can the contractor be wrong? That's the question I'm asking.
Yes.
I agree. I understand your argument, your
Yes.
role. That is appreciated.
Yes.
There's no difficulty on that. But there is an academic angle to it, which we have to also examine. So the Nalbari Municipal Board finds the chairman was right, but the contractor was wrong because the chairman did not get certain things done in a certain manner. Is this argument not fallacious? If immediately action was taken against him, then the court would have said that you ought to have proceeded against the chairman.
Against the chairman.
In 1 year.
What do you have to say on that?
Since there was no proceeding against the earlier chairman, my lord, who issued the work order.
Correct, because it may be that the board would not have agreed. It may be that the board would have agreed. It was just a formality. The board would have easily ratified the decision. Maybe the chairman did not notice it.
The other aspect of the case, my lord, this fund is of municipal board's fund. A fund was provided by the district urban development agency. And they are to provide it, but
That
it
the-
was not provided, but the work order was issued.
All right, these are internal matters, but then if you made a person do the work, supply the materials, now can you say that fund was not provided, this was not?
We have not taken such stand that it was not supplied, not received by the municipal board.
That's
we
right.
have not-
So if there was dispute that whether he has at all executed the work, then it was a different.
It is contractor's duty also, my lord, to see regarding that, my lord, regarding administrative. Nowadays, a law have been developed, my lord. It is a responsibility of contractor also, my lord.
That's correct. That is the recent trend.
Yes, my lord.
But for 68,000 rupees,
All right, my lord. I have understood what your lordship is saying.
the courts have to be having a human approach also.
Only the observation may be made, my lord, in the judgment itself, my lord, regarding the section 64 I have submitted before your lordship. my lord. So that, my lord, that can be seen by the others, chairman also, whoever comes in.
Yes.
My lord, super chief's my lord, observation as this.
Where is the decision on quasi contract?
But so far, madam, section 54 of the Assam Municipal Act, madam.
Hmm.
But since no action has been taken up for violation of any terms in the section 64, madam, of Municipal Act. So it is madam admitted by the municipality board that action has been done and by the chairman lawfully, and everything has been carried out by this. And so far, my other part is concerned, there is two parts, madam, contract and supply, madam. The main work is relating to construction of a drain, madam. For construction of that drain, my lord, it may be carried out through a different scheme by the municipality itself or through other person. So for that part is concerned, tender, whether there is floating of any tender is there or not, it is within the knowledge of the municipality. But in relation to construction of that drain, I am not authorized to construct the drain. I am only authorized to supply some materials to construct the drain. And supplying the materials that is admitted. But after getting the supply materials, what the municipality board has done with that materials, madam, it is within the knowledge of the municipal board. If the drain was carried out subsequent to that, my lord, meaning the work has been done, right? And so
So
for
your client made the supply to the municipal
board,
board or the contractor?
municipality board, madam, as part of executive.
Hmm.
They have received, there is no dispute as regards to receipt of the materials, madam. And so for the main contract is concerned for construction of drain, it is done by the municipality board, either municipal board itself or through other person. I am not aware of that, madam. It has to be revealed by the board itself, madam. And so for the section 54 of the municipal board act speaks, if any term is condition of the act is violated by any person, chairman including chairman, within 1 year, madam, from the date of cause of
Just 1 minute. Yes. So, yeah. Can come on the board. Yes.
So far, section 54 is concerned, my lord, of the municipality act, my lord. The board has to taken up any action as regards
Well,
to
you said that already.
so far, section 29 is also, my lord, empowers the chairman to do execute or to-
Section 29.
29. my lord. So you have 37 members, 37. Powers of chairman, my lord. Subsection 2, my lord.
So was there any urgency in this matter?
My lord, so far the supply of materials concerned, it relates to a construction of drain, my lord. So whether that is any, my lord, emergency or not, obviously, my lord, it is within the my lord, knowledge of the municipality board. They ought to have been proved that there is no urgency or that was, my lord, done as part of section 106 of Evidence Act, my lord. And so far, my lord, the action of the chairman is concerned as regards to violation of section 64 of the Municipality Act is concerned, that ought to have been, my lord, initiated any proceeding against that particular person, any loss or anything, my lord, within 1 year, my lord. Section 54, my lord, may I review also?
Section 50,
54, my lord.
yes.
Every chairman, vice chairman, commissioner, officer, or servant of a municipal board, including a government servant, whose services are lent to the board, shall be liable for the loss, worst, or misapplication of any money or other property owned by or vested in the municipal board. If such loss, worst, or misapplication is a direct consequence of any illegal act, commission, neglect, or misconduct on his part, and a suit for compensation may be instituted against him in any court of competent jurisdiction of the board. Every such suit shall be instituted within 1 year after the date on which the cause of action arose, my lord.
No, that is another matter.
Right.
Anyway, just let us see the evidence, what is
Right.
there. Yeah, LCR, evidence. LCR to the.
So for the admission of supply is concerned, BW2 is the one of the employee of the municipality board, and DW1 is the chairman who has contested the suit.
Please take, can you please take out the evidence of PW 1 and 2?
1 and 2, as well as DW1 also, my lord,
Yeah,
DW
you
admitted.
please flag it. We'll go through it once. So there were two PWs and one DW.
My lord.
PW1 is the plaintiff himself.
Plaintiff, my lord. PW2 is the one of the employee of the board. He was summoned by the court, my lord. He appeared.
All right, where are the evidence?
My lord. I have flagged it now.
All right. Anything else, Mr. Chaudhary?
The whatever is submitted regarding section 54, my lord. It is regarding.
No, 54.
Action.
We are not going into that.
The other matters already I have.
It's a second appeal. We'll just see whether there is any perversity in the finding. It's concurrent finding.
Yes, madam.
Concurrent finding, the court will not interfere unless there is any perversity in the view. Only to that extent, it will be a short judgment.
Yes.
There is no scope of reappreciating evidence and
Yes.
coming to that, you know. In a second appeal, only the substantial questions are heard. Mr. D. Chaudhary, learned counsel, assisted by Mr. N.
Right.
Rai,
Right.
RAI,
RAY.
ROY,
RAY.
RAY,
Yes.
N. Ray. Learned counsel appearing for the appellant. Also heard Mr. M.K. Sharma, learned counsel representing the respondent. First up. This second appeal is directed against the concurrent judgment and decree dated judgment and decree dated 3/8/2013. 3/8, is it?
Yes, ma'am.
2013, passed by the learned civil judge, Nalbari, in connection with money appeal number 2/2012. Partially affirming the judgment dated 11/9/2012, passed by the learned Munsif number 2, Nalbari, in Manisuk number 35/2010. First up. The second appeal was admitted to be heard on the following substantial questions of law. We will get it in order dated 23/5/2014. The two substantial questions of law are concerned. First up. The respondent as plaintiff had earlier instituted money suit number 35/2010, praying for a money decree for a sum of rupees for recovery of a sum of rupees 83,340 from the appellant stroke defendant Nalbari Municipal Board. First up. Nalbari Municipal Board on account of the materials supplied by him. Stop. The plaintiff's case in a nutshell is that on (21/6/2008), the then chairman of the Nalbari Municipal Board had issued a work order under memo number NMB/PWD, all capital, /4/2008-09/131 for supply of certain materials for the purpose of construction of a concrete drain at Fakirtola, Fakirtola, Fakirtola Road, Ward number 5 of Nalbari. First up, as per the work order, bracket exhibit 1. Work order is the exhibit 1.
Exhibit 1, madam.
Exhibit 1. The plaintiff stroke respondent was asked to supply first class bricks 1 first class brick, first class standard brick bats, BRICK BATS, cement, quarry sand and stone chips. Accordingly, the plaintiff had made those supplies and submitted a bill for amount of rupees, for payment of rupees 68,600. The chairman of the municipal board had approved the bill and recommended payment to be made to the plaintiff oblique respondent. Full stop. However, when the matter was sent to the administrator of the board, no action was taken for clearing the outstanding dues of the plaintiff oblique respondent. Full stop. Situated thus, the plaintiff had submitted a demand notice had submitted demand letters, bracket exhibits 3 and 4, bracket close, and thereafter instituted the money suit for recovery of the principal amount of 68,600 together with interest at the rate of 9% per annum on the said amount, being rupees 14,740, thus totaling to a sum of rupees 83,340. First stop. The appellant Nalbari Municipal Board contested the suit by filing written statement. Based on the pleadings of the parties, the learned trial court had framed the following issues. We will get the issues in page number 32. Following issues. Full stop. Full stop. In support of his case, the plaintiff had examined himself as PW1 and Sri Panindra Talukdar Assistant Engineer of Nalbari Municipal Board, as PW2, full stop. PW2 and also exhibited certain documents, including the work order, bracket exhibit 1, full stop. The defendant side had examined the chairman of the Nalbari Municipal Board as DW1, full stop. And exhibited certain documents, including the work order, bracket exhibit 1, and the bill submitted by the plaintiff against supply of materials, bracket exhibit 2, full stop. On conclusion of trial, the learned trial court had decided all the issues in favor of the plaintiff stroke respondent and decreed the suit for recovery of an amount of rupees 68,000 and decreed the plaintiff's suit for recovery of rupees 68,600 along with interest at the rate of 8% per annum from the period from 23/8/2008 till 20/12/2010. Full stop. The learned trial court had also awarded interest at the rate of 6% per annum on the aforesaid amount to be calculated from the date of filing of the suit till realization of the same. Full stop. Being aggrieved by the judgment and decree dated 11/9/2012. Is it 11/9/2012?
Yes.
Trial court judgment and decree
11/9/2012.
11/9/2012. The respondent as appellant had preferred money appeal number 2/2012, which was also partly allowed by the learned first appellate court. By affirming the decree insofar as the recovery of rupees 68,000 along with 6%, along with interest at the rate of 6% per annum from the date of submitting the bill till realization of the decretal amount is concerned. First step. However, the learned lower appellate court had interfered with that part of the decree passed by the trial court, whereby interest at the rate of 8% per annum was awarded for the period from 23/8/2008 till 20/12/2010. Full stop. How are these dates relevant? 23/8/2008 is the date of the bill.
My lord.
That is from the date of submission of the bill till institution of the suit. 2012/2010 is institution of the suit.
Yes, my lord. December 2010, my lord.
Full stop. Aggrieved thereby, the instant second appeal has been submitted. Full stop. Yes, instant second appeal has been preferred. Full stop. By referring to the materials available on record, Mr. D. Chaudhary, learned counsel for the appellant, has strenuously argued that the work order dated so and so was unauthorized in as much as the then chairman of the Nalbari Municipal Board did not comply with the requirements of Section 64 of the Assam Municipal Act 1956. By obtaining the approval of the board, without which the appellant board could not have executed a contract. Moreover, submits Mr. Chaudhary, no tender notice was floated before issuing the work order to the plaintiff stroke respondent. It is also the submission of Mr. Chaudhary that the work in question was required to be executed with the financial assistance provided by the district
Urban Development Agency.
by the Nalbari District Urban Development Agency, bracket DUDA, bracket close. And since no such fund was provided by the aforesaid agency, the question of the board making payment to the petitioner did not arise. Full stop. Mr. Chaudhary has, however, in his usual fairness, submitted that the board is not denying or disputing the fact that the plaintiff stroke respondent had in fact supplied the materials in terms of the work order dated
21/6/2010.
21/6/2008. Full stop. Next, responding to the above arguments, Mr. Sharma submits that since the plaintiff stroke respondent was not required to construct the drains, hence there was no question of executing any contract agreement with him. As such, Section 64 of the Assam Municipal Act 1956 would not have any application in the facts and circumstances of the case. First up, according to Mr. Sharma, the then chairman of the Nalbari Municipal Board had merely asked the petitioner to supply certain materials, and in view of the provisions of Section 54 of the Act of 1996, the chairman of the board did have the power to issue such orders if the same is required in the exigencies of public service and for public safety. Public safety etc. First of all, since the procedure to be followed while issuing the work order was an internal matter for the Nalbari Municipal Board to consider, and in view of the fact that the board has not initiated any action against the then chairman for issuing the work order to the plaintiff, considering the fact that the supply has been made by his client, the appellant cannot refuse to make payment for the goods and supply goods and articles received by them. Full stop. Under the circumstances, submits Mr. Sharma. There is no scope for this court to interfere with the concurrent finding of facts recorded by the learned court below. Stop. I have considered the arguments advanced by learned counsel for both the parties and have also gone through the materials available on record. Full stop. As have been noted herein above, the plaintiff has exhibited Exhibit 1, that is the work order dated 21/6/2008, and as well as the bills submitted by him for a sum of rupees 68,600 bracket Exhibit 2, full stop. The PW2 has duly supported the PW2, who is an official of the appellant board and was fully aware of the facts and circumstances of the case, has also deposed before the court supporting the case of the plaintiff. Full stop. Full stop. The appellant board has not denied or disputed the fact that the plaintiff has in fact made the supply of the materials indicated in the work order dated 21/6/2008. Full stop. There is also no complaint against the plaintiff as regards the quality of the articles, quality of the materials supplied, as well as the time period within which the same was made. Full stop. If that be so, and considering the fact that the plaintiff had never intended to make those supplies in a gratuitous manner, even if there is no contract agreement executed between the appellant board and the plaintiff, the matter would be squarely covered. The matter would, in the opinion of this court, squarely fall within the ambit of Section 70 of the Indian Contract Act 1872. Full stop. Section 70 is quoted herein below for ready reference. Full stop. Quoted. Full stop. The learned counsel for the appellant could not invite the attention of this court to any material available on record to show that the plaintiff had not supplied the materials in a lawful manner. Full stop. The bill submitted by the plaintiff, bracket exhibit 2, bracket close, bears ample testimony of the fact that the plaintiff had never intended to make those supplies gratuitously. Full stop. It is also not denied that the materials supplied by the plaintiff under work order, bracket exhibit 1, comma, was used for the purpose of construction of the public drain. Full stop. If that be so, there cannot be any question of denying payment to the plaintiff for the materials supplied by him. Full stop. Insofar as the argument advanced by Mr. Chaudhary regarding non-compliance of Section 64 of the Act of 1956 is concerned, full stop. This court is not convinced with such argument for the following reason, full stop. Firstly, Section 64 would come into play when there is a contract agreement executed by the board would come into play when the board enters into a contract for the purpose of fulfillment of any of the provisions of the Act. Full stop. It is in such circumstances that the contract would have to be ratified and or approved, sanctioned in a meeting, sanctioned in a board meeting, and the same will have to be in writing and signed by at least 2 of the members, one of whom shall have to be the chairman or vice chairman, and shall be sealed with the common seal of the board. First step. Unless so executed, such contract shall not be binding on the board. First step. Since there is no contract executed between the board and the plaintiff stroke respondent, the question of Section 64 would have no relevance in the facts and circumstances of the present case. Full stop. Secondly, even assuming that the work order dated 21/6/2008 was issued by the said chairman in an unauthorized manner, the appellant board ought to have initiated action against the then chairman as and when the same was detected. Full stop. However, it is the admitted position of fact that no such action was initiated against the chairman. Full stop. Full stop. That the above fact, viewed in the perspective of the circumstances of the case, in the opinion of this court, would amount to tacit approval of the action on the part of the then chairman of the Nalbari board. Full stop. If that be so, the appellant cannot be permitted to defeat the decree, permitted to deny the fruits of the decree passed in favor of the plaintiff stroke respondent merely by taking such technical pleas which have been found to be wholly untenable in the eye of law. First of all, for the reasons discussed in hearing above, I am of the opinion that there is no scope for this court to interfere with the concurrent decree, judgment and decree passed by the learned trial court, in as much as the decree passed by the learned court below does not suffer from any infirmity or perversity in the eye of law system. The substantial questions of law stand answered accordingly. The appeal is held to be devoid of any merit and is accordingly dismissed. Registry to send back the LC. There will be no order as to cost.
Well, appellate court hold that the PW1, plaintiff witness 1 and 2 has contradicted each other on the point of place of second transaction. And there were disbelieved. My lord, and
1 minute, 1 minute.
my lord.
Yes,
My lord, the second point is, my lord, the issue number 2 and 3 was wrongly decided so as to disbelieve the execution of the hand note exhibit A and B.
you are the defendant.
My lord, I am for the plaintiff, my lord,
You are for the plaintiff.
plaintiff.
Suit was originally decreed.
My lord, decreed, my lord. Trial court has decreed.
Then first appellate court.
First
reversed.
appellate court reversed the holding mainly primarily, my lord, the first appellate court find contradiction of the PW1 and 2 evidence so far relates to the place of transaction. Whereas, my lord, PW1 did not specifically mention the place of transaction of the second transaction. He has not made any specifically. But the
Let us see the judgment of the trial court.
my lord. Trial court judgment, lord, you will find starts from page 12. May I read out?
Page 12.
Page 12. My lord. Trial court judgment. May I read out, my lord. This is a suit for recovery of money of rupees 2 lakh only. The plaintiff's case in a nutshell leading to the institution of this suit is that let Dilip Ghosh being dependent numbers 1 husband and dependent numbers 2's father approved the plaintiff on 1/5/2010 and thereafter borrowed an amount of 40 from the plaintiff on the pretext of development of his enterprise named Manik Enterprise and thereafter executed a hand note for the same on 30/12/2011. Again, let Dilip Ghosh sought financial help from the plaintiff for his treatment in Mumbai. The plaintiff agreed and then paid rupees 1,40,000 to let Dilip Ghosh and he promised to repay the same with interest by executing a hand note. Let Dilip Ghosh also stated that his legal heirs would be bound to pay the same in his absence. Then on 2/6/2012, Dilip Ghosh died. And after around a month, the plaintiff made the dependents being the legal heirs of the deceased and asked them to repay the loan. The dependents promised to repay the same as early as they could. But as days passed, the dependents refused to pay the loan amount and interest interest accrued thereon. Finding no other alternative, the plaintiff served a legal notice to the defendants on 3/10/2012, asking them to repay the loan amount of rupees 1,80,000 with interest accrued within 15 days from the date of receipt of notice. But the defendants did not communicate regarding the same with the plaintiff and also failed to pay the amount. Hence the present suit. The defendants entered their appearance and contested the same by filing WS. In their WS, the defendants have denied the case of the plaintiff in 2-2. The defendants have stated that the plaintiff is not entitled to recover any amount from them. They denied that late Dilip Ghosh executed any hand note in favor of the plaintiff and denied the signatures on the hand note to be that of late Dilip Ghosh. They also averred that deceased never told the defendants about taking any loan during his lifetime from the plaintiff. Heard the arguments of the learned counsel for the plaintiff, perused here meticulously. Based on the rival submission of the party, the following issues are framed: whether there is a cause of action for the suit, whether the plaintiff paid rupees 40 as a loan to late Dilip Ghosh, the father of the defendant number 2, on 1/5/2010, who accepts the same by executing hand note, and again on 30/12/11, the plaintiff again paid rupees 1,40,000 to late Dilip Ghosh, who accepted the same by executing hand note and promising to repay the loan with interest on demand. Whether late Dilip Ghosh executed the hand note for accepting the money from the plaintiff, whether the defendant defaulted in repayment of the loan amount of money of rupees 1,80,000 to the plaintiff after remand of the same to the plaintiff, whether the plaintiff is entitled to the reliefs as paid for. Discussion, decision, and reasons thereof. Issue number 1, from the the deposition of the PW1 and PW2, it is seen that late Dilip Ghosh, who is the husband, father of the defendants, borrowed rupees 40,000 on 1/5/2010 and rupees 1,40,000 on 30/11/2011 from plaintiff, with the promise to return the same with interest, and that these legal heirs would also be liable for the same. Late Dilip Ghosh also executed 2 hand notes of the same. The said hand notes are submitted by the plaintiff in court and duly exhibited it. But Dilip Ghosh died, and therefore, when the plaintiff went to ask for his money from the defendants refused to repay back the same. On the other hand, the defendants have averred that late Dilip Ghosh never borrowed any money from the plaintiff and that no hand notes were ever executed by the deceased. The defendants and all the defendants witness also stated that the defendants are in no way liable to repay any money to the plaintiff. Now, from the rebel submission of the both sides, there is clearly a cause of action for this suit. Issue number 2, 3, and 4. For the sake of brevity and convenience, the above issues are taken together. Only the 11 portions of the evidence are taken into consideration. PW1, the plaintiff Madan Chandra Nath differs that he knows the husband, father of the defendants, being his friend, and that he also owned a shop in Mangalore town named Manik Enterprise. He stated that on 1/5/2010, he lent rupees 40,000 to late Dilip Ghosh on the promise that the same would be returned to him with interest. Thereafter, again on 30/12/11, late Dilip Ghosh borrowed rupees 1,40,000 from him on the pretext of his ailment. Late Dilip Ghosh also promised that he would return the same with interest. He further stated that later late Dilip Ghosh, in presence of the defendants and the witnesses, executed a hand note that he owed rupees 1,80,000 to the plaintiff, and that he or in his absence his legal heirs would be liable to return the said amount. Then on 2/6/2012, Dilip Ghosh died battling an ailment. Since then, he has visited the defendants several times, asking them to prepay the loan amount. Initially, the defendants stated that they would prepay the amount as early as they could, but eventually, as days passed, the defendants refused to repay the amount. He also stated that he has filed this suit for recovery of rupees 2 lakh with the principal amount and interest. He exhibited the hand note executed by late Dilip Ghosh for the amount of rupees 40,000 and exhibit A1 is the signature of late Dilip Ghosh. Exhibit 2 is the signature of the writer Bhadrakanta Deka. He exhibited other hand note for an amount of rupees 1,40,000 as exhibit B, and the signature of the late Dilip Ghosh and writer Bhadrakanto. Well, something wrong, my lord. Bhadrakanto, it should be Decca, my lord, written Ghosh as exhibit B1 and B2 respectively. PW to Bhadrakanto Decca deposed that he knows both the plaintiff and the defendant. He stated that he is the writer of exhibit A, and through it, late Dilip Ghosh took money from the plaintiff on loan. He exhibited his signature as exhibit A2. He further stated that through exhibit B, late Dilip Ghosh again borrowed rupees 1,40,000 from the plaintiff. He also stated that he is the writer of the said exhibit B, and he exhibited his signature as exhibit B2. Both the plaintiff witnesses were examined by the defendant side. In his cross-examination, PW1 stated that no one signed as witnesses on exhibit A and exhibit B. He stated that the total amount which he lended was rupees 1,80,000, and that the said money was his pension money. He stated that he has not taken any signature from the defendants in spite of their presence, citing that their husband father has borrowed money from him. He denied the assertion that he does not work at irrigation department, that he is actually a money lender who lends at interest. PW2 stated that on 5/1/2010, he was executed at the house of the plaintiff. He further stated that the defendants were present at the time of the execution of the hand note, but their signatures were not taken. He also added that exhibit B was executed at the house of late Dilip Ghosh, and that no one signed on it as witnesses. He also deposed that he does not recall the dates on which he went to the house of the defendants along with the plaintiff. He denied the assertion that he has falsely prepared exhibit A and exhibit B in collusion with the plaintiff. On the other hand, DW1 Pompa Ghosh in her affidavit deposed that her deceased husband never took a sum of rupees 40,000 and rupees 1,40,000 on 1/5/10 and 30/12/11 respectively from the plaintiff for development of his enterprise and for his statement. She further stated that her late husband never sought any financial assistance from the plaintiff by executing any hand note. She further stated that she does not know the plaintiff and the PW2, and that the signatures on the exhibit do not belong to her husband. She also deposed that late Dilip Ghosh never told them about they being liable for any debt, and that the plaintiff and the PW2 never came to their house asking for recovery of money. DW2 Ranjan Dekha, who is an employee at Manik Enterprise, deposed that had the deceased borrowed money from anyone, he would have had knowledge of the same. He further stated that he has never seen the plaintiff come to their shop, and that the signatures on the hand notes does not belong to the deceased. He also stated that the deceased never borrowed rupees 1,80,000 from the plaintiff. DW2 Ojit Ghosh deposed that he knows the deceased Dilip Ghosh, as he has a hardware shop next to that of Manik Enterprise. He also stated that he has never seen the plaintiff come to the shop of the deceased. He also stated that he recognizes the handwriting of late Dilip Ghosh, and that the signature of the exhibit does not belong to the deceased. Further, he corroborated DW1 and DW2 by citing that late Dilip Ghosh never borrowed rupees 1,80,000 from the plaintiff. All the DWs were cross-examined by the defendant. There may be some wrong. DWs were cross-examined by the plaintiff. DW1 in her cross-examination stated that her husband, late Dilip Ghosh, used to do all the transactions pertaining to his shop. She further stated that he fell ill 3 months before his death, that he sought treatment in Mumbai. She denied of receiving the legal notice dated 3/10/2012. She also denied the assertion that as a huge sum was spent on the deceased treatment, she is now unable to return the money to the plaintiff. DW stated that he has been working at the shop of the deceased for the last 10 years. He stated that in his absence, if the plaintiff has come to the shop then he is not aware. He further stated that on 1/5/10 and 30/12/11, he was present in the shop along with Dilip Ghosh and that no transactions happened. He also stated that late Dilip Ghosh used to sign in English. He also stated that Exhibit A is written on the letterhead of of their shop's notepad. DW3 stated that he often keeps busy at his shop and that view from the shop to the deceased shop is not clear. He stated that he has signed on head note, but he has not seen his signature on Exhibit A, B. He also stated that as he had good relations with the deceased, he used to lend and borrow money from the deceased. Now, from the discussion above, it is to be seen whether the exhibits were genuine or not. By a mere glance on both the exhibits, it can be concluded that the writer of both the exhibit is one and the same person. Also, the signature of late Dilip Ghosh on both the exhibits are similar. Moreover, the very fact that Exhibit A is written on the letterhead of the notepad of the deceased shop cannot be overlooked. Also, DW2, the employee of the late Dilip Ghosh has recognized the Exhibit A and has admitted that the said letterhead belongs to their shop's notepad. Both the DW2 and DW3 have also stated that late Dilip Ghosh used to sign in English. The signature of the deceased on the exhibits are signed in English and PW1 has duly exhibited the same as he recognizes. The writer of the exhibits, PW2, is duly examined and he has stated that deceased did borrow money on 2 occasions for which 2 hand notes were executed and that he is the writer of the same. He also notes nothing is brought forward by the defendant's witnesses to prove that the Exhibit A and Exhibit B are not genuine. Hence, the same should be disbelieved. There is, however, one lacuna on the part of the plaintiff as there was no witnesses to the hand notes exhibits. But the fact duly corroborated by both the PWs that both the exhibits were executed at the house of late Dilip Ghosh and at that time late Dilip Ghosh and his family and the plaintiff and the PW2, no one were present is believable. As the transaction of money and execution of hand notes were done in house, the fact that witnesses were not present is probable and can be considered. As also, DW1 in her deposition refused to acknowledge that the plaintiff came to her house asking for repayment of money. But this fact is not substantiated by any material particulars. The plaintiff also sent a legal notice dated 30/10/2012 to the defendants asking for his money back, but the plaintiff failed to exhibit the said document, also failed to mention about it in his affidavit, so the same could not be taken into consideration. It is also averred by DW1 that a huge sum of money was incurred by the treatment for her deceased husband. So it can be assumed that she failed to repay back the money taken from the plaintiff by her late husband due to financial terms. Accordingly, the case of the plaintiff is believable as he has been able to establish his case by preponderance of probabilities. From the above discussion, it is clear that the plaintiff made a lawful claim of his money of ₹1,80,000 with interest from the defendants being the legal heirs of deceased, but they failed to repay the same. All these above issues are hereby decided in the affirmative. Accordingly, it is held that plaintiff is entitled to recover principal amount of ₹1,80,000 with any interest, without any interest on it. The plaintiff is also entitled to interest at the rate of 5% on the dictatorial amount from the date of suit to the date of decree. My lord, the suit was accordingly decreed on contest, my lord.
Yes.
Not this. This was been reversed by the first appellate court. Primarily finding, giving a finding that there has been a contradiction in between PW1 and 2 regarding the place of second transaction. My lord,
Let us read from page number 28.
yes, my lord. Discussion, decision, reasons thereof, my lord. My lord, a point for determination, whether the judgment and decree passed by the learned court is sustainably in law and in fact or warrant any interference. I have heard the argument, but put forwarded by the learned advocates of both the parties and also peruse the entire evidence and matters on record. From perusal of the case record, it appears that the crux of the suit lies within the decision of the issue number 2 and 3. Hence, for convenience, I have decided to discuss only these two issues for the decision of the present appeal. The plaintiff as PW1 has filed affidavit contending that late Dilip Ghosh was his friend. He had business establishment with the name and style of Manik Enterprise in Mangalore town. On 1/5/2010, he approved the plaintiff for a loan of ₹40,000 for developing his business. After a few months, when late Dilip Ghosh fell ill, he again approved the plaintiff for help and advanced him a loan of ₹1,40,000 on 30/12/2011. The deceased had taken both the loans with promise to return the same on demand with interest. Late Ghosh had executed a hand note in presence of his wife and son, acknowledging the loan of ₹1,80,000. He also promised that in his absence, his legal heirs will be liable to repay the loan amount to the plaintiff. PW1 had exhibited the hand notes in court as Exhibit Co and Exhibit Co. Dilip Ghosh expired on 2/6/2012. After his death, the plaintiff requested the defendant to return the loan amount to him, but the defendants never paid any heed to his request. Plaintiff's side had proved the execution of Exhibit A and B by calling the scribe Bhadrakanta Deka to the witness box. Sri Bhadrakanta Deka stood in the witness box as PW2 and stated in his affidavit that both the exhibit and A and B were written by him and in his presence. Late Dilip Ghosh had put his signature on both the executed documents. According to him, at the time of execution of Exhibit A and B, the defendants were also present. His evidence revealed that he was acquainted with the signature of late Dilip Ghosh. The defendants had denied the whole case of the plaintiff. They are pleased that they neither knew the plaintiff nor the scribe Bhadrakanta Deka. Their father husband had never taken any loan from the plaintiff, and he did not ever executed any hand note acknowledging the same. They have categorically denied the allegations, alleged signatures of late Dilip Ghosh in both the exhibits A and B, which were identified by the scribe as Exhibit A1 and Exhibit B1. Learned counsel for the appellant has submitted that it is the duty of the plaintiff to prove his case as per balance of probability. The plaintiff has relied on Exhibit A and B to prove their case. Hence, they have to successfully prove the execution of the documents as per law. Although the PW2 has stated that he knew the signature of late Dilip Ghosh, he has not clearly stated how he was acquainted with the signature of late Dilip Ghosh. It was the duty of the plaintiff to prove the signature of late Dilip Ghosh by independent witness. Question of sending the signature for expert opinion does not arise because of the death of the alleged signatory. Although the document could have been seen to the handwriting expert, there would not have any admitted signature of the alleged signatory. So it was incumbent on the plaintiff that he would have proved the signature by someone who actually knew it. Learned counsel for the appellant has further argued that mere proving the execution will not dispense with the responsibility of proving the content of the said documents. He has submitted that the plaintiff side has showed 3 different stories regarding the transaction of the money alleged to have advanced to the father husband as loan. PW1 has stated in his affidavit that when Dilip Ghosh fell ill, he went to the plaintiff and asked for another loan of ₹1,40,000, and the plaintiff immediately handed over the amount to Dilip Ghosh. This statement shows that the transaction took place in the house of the plaintiff. On the other hand, from the evidence of TW2 Bhadrakanta Deka, it appears that exhibit B was executed in the house of Dilip Ghosh and exhibit B was executed in the plaintiff's house. Since the plaintiff's plea is that as soon as the father, husband of the defendant received the money, he had executed exhibit A and B, and inference can be drawn that as per version of the PW2, the first transaction took place in the house of plaintiff, and the second transaction took place in the house of Dilip Ghosh, which shows that PW1 and 2 had contradicted each other. Well, this is very important. Well, it is stated legal proposition that in a money suit, the plaintiff has to prove the place of transaction person in presence of whom the transaction took place and the amount of transaction. From the aforesaid discussion, it can be gathered that the plaintiff has not been able to discharge his burden of proving his case in the first hand. It is clear that the defendants have denied all the allegation level against their deceased father, husband. In this case, the person against whom the allegation is level is no more in this world to defend his case. Under such circumstances, the responsibility of the plaintiff becomes more to prove the case in all probable possibilities. The Honorable Supreme Court head court in the H. Kantilal versus P. Patel versus D.J. Rathod reported so-and-so, opined that matters pleaded by plaintiff, controverted by the defendant, has positively proved by the plaintiff, not negatively disproved by the defendant. Since the existence of fact can be proved by reasonable evidence, but the non-existence cannot be proved in circumstances. Accordingly, order was passed, my lord. Accordingly, from the aforesaid discussion, it is clearly appeared that the plaintiff defendant has failed to prove the case as pleaded by producing material evidence. Accordingly, it is held that the plaintiff is not entitled to any degree as paid for. The appeal is allowed. Impugned judgment passed by the landed trial court is set aside. Accordingly.
So the court says execution of exhibit A and B could not be proved.
My lord.
So the
My
whole
lord.
case is based on A and B, exhibits A and B.
Yes.
If the execution of these two documents is not proved,
My lord, the writer was examined, my lord. Who writes the exhibit A
but
and
there was no witness.
my lord, that my lord, what is the basis of not giving witness, my lord? The person who exhibited, who written the my lord, both the notes and notepad was the document, my lord, papers that was executed, and that has been admitted by DW2. It was the notepad, and he also admitted that the deceased used to sign in English. That is,
Or even if that is accepted,
my lord.
that would only apply to exhibit A, not to exhibit B.
My lord, exhibit B, my lord, yes, my lord, both are written in notepad. My
Let
lord.
us see where are the
Lordship,
details.
kindly have a look at the records, my lord.
Let's see exhibit A and B.
My lord. And the court finding of the appellate court so far second place of transaction, that is based on presumption, that is not on fact. My lord, I'm leg marking the exhibit A.
Evidence.
Yes,
Cross. Cross. Possibility. See.
Yes.
TW possible. TW.
Cross. PW1 to BM1. PW1. PW1. PW2. Cross. জানবে না এই মোটামুটি executive দোকানত পেটত নাই ওকে সব ada aja sal Look, I have flag marked the both exhibit A and B. And also the cross of the evidence of both sides. It is signed by the Dilip Ghosh on the revenue ticket and also signed by the writer. First transaction was 1/5/2010, paying 40,000. In the second time, 30/12/2011, 140, but total amount is also mentioned.
Hmm.
My lord, the writer was the independent witness, he was examined. And my lord, the first appellate court basically, my lord, disbelief recorded finding about the contradiction of the evidence of PW 1 and 2, holding that the first transaction was in the house of as per the Dilip Ghosh, but my lord, the DW2, the first transaction was made in the house of the plaintiff, and the second transaction was also made in the house of the plaintiff. But PW2 has said that the second transaction was made in the house of defendants, my lord. And recording this as a contradiction, my lord, the disbelief the whole evidence. Whereas, my lord, the PW1 has never stated where the second transaction was made. Lordship may kindly have a look at the evidence of the PW1 and 2, my lord.
Yes.
That I have also marked PW1, my lord. Sorry, my lord, PW1, my lord, I am also, my lord, I am also, I am reading, my lord, only the cross part, my lord. Whether sheep, my lord, is recorded, my lord, necessary, my lord, I have not flag mark.
You place whatever you want to place.
My lord, I am reading the, my lord, cross part of PW1. মই আগতে পত্ৰ শপত দাখিল কৰিছো আৰু কিছু কাগজ পত্ৰ জমা দিছো প্ৰদৰ্শক A hand note and exhibit A বিবাদী দিলীপ ঘোষৰ সহি now deceased exhibit A2 লিখক ভদ্ৰকান্ত ডেকাৰ সহি মই চিনি পাও দিলীপ ঘোষে বাদীৰ পৰা প্ৰথমবাৰ ৪০,০০০ টকা দ্বিতীয়বাৰ exhibit B যুগে ১,৪০,০০০ টকা লৈছিল exhibit B1 মৃত দিলীপ ঘোষৰ সহি আৰু exhibit B2 লিখক ভদ্ৰকান্ত ডেকাৰ সহি মই চিনি পাইছো exhibit A আৰু B খনত সাক্ষী হিচাপে কোনো লোকৰ সহি নাই এই টকাটো মুঠ ১,৮০,০০০ টকা মোৰ পেনশনৰ টকা মই ৩০/১২/২০১১ তাৰিখে মই বেংকৰ পৰা কিমান টকা উলিয়াইছিলো এই বিষয়ে মোৰ আৰ্জিত উল্লেখ নাই মই দিলীপ ঘোষৰ পত্নী আৰু সন্তানৰ ওপৰত উত্তৰাধিকাৰী সূত্ৰে এই গোচৰ কৰিছো দিলীপ দাসে মোৰ পৰা ব্যক্তিগত লোন লৈছিল তেওঁ কি কামৰ বাবে মোৰ পৰা লোন লৈছিল মই নাজানো পম্পা ঘোষ আৰু মানিক ঘোষ বৰ্তমান সাবালক আৰু বিবাদী পইচা ধাৰে দিয়া সময়ত তেওঁৰ ল'ৰা মানিক ঘোষ সাবালক আছিল মই বৰ্তমান বিবাদী গণৰ পৰা দেউতাক ঘোষে মোৰ পৰা ধাৰ লোৱা টকাৰ বাবদ কোনো সহি লোৱা নাছিলো ২০১২ চনত বিবাদী দিলীপ ঘোষ ঢুকাইছে যদিও বিবাদীগণ উপস্থিত আছিল তেওঁলোকৰ সহি exhibit A আৰু exhibit B খনত লোৱা হোৱা নাছিল মই মোৰ আৰ্জি আৰু পত্ৰত বিবাদী দিলীপ ঘোষক পইচা খুজিব যোৱাৰ কথা উল্লেখ কৰা নাই মই আন কাকো এনেদৰে পইচা ধাৰে দিয়া নাই মই ইৰিগেশ্যন ডিপাৰ্টমেণ্টত মই চাকৰি কৰিছিলো এইটো সত্য নহয় যে মই চাকৰি নকৰো আৰু টকা দিয়া ব্যৱসায় কৰো এইটো সত্য নহয় যে বিবাদীয়ে মোৰ পৰা টকা ধাৰলৈ লোৱা নাছিল এইটো সত্য নহয় যে মই বিবাদী গণৰ ওপৰত এইটো মিছা গোচৰ দিছো my lord nowhere is mentioned that the second transaction was made in his house my lord. Then my lord the PW2 my lord ভদ্ৰকান্ত ডেকা I have marked my lord মই আগতে পত্ৰ শপত দাখিল কৰিছো মই বাদী আৰু বিবাদী উভয়কে চিনি পাওঁ বৰ্তমান বিবাদী ঢুকাইছে প্ৰদৰ্শক এ যোগে দিলীপ ঘোষে বাদীৰ পৰা ধাৰে লৈছিল প্ৰদৰ্শক এ টু লিখক হিচাপে মোৰ চহী আৰু পিছত আকৌ দিলীপ ঘোষে প্ৰদৰ্শক বি যোগে 1,40,000 টকা ধাৰে লয় আৰু প্ৰদৰ্শক বি টু লিখক হিচাপে মোৰ চহী প্ৰদৰ্শক এ খন 1/5/2010 তাৰিখে সম্পাদন হৈছিল প্ৰদৰ্শক এ খন বাদীৰ ঘৰত সম্পাদন হৈছিল He has specifically mentioned that exhibit was in the house of plaintiff. সেই সময়ত দিলীপ ঘোষৰ ঘৰৰ মানুহ উপস্থিত আছিল আৰু তেওঁলোকৰ মই সাক্ষী হিচাপে চহী লোৱা নাছিলো প্ৰদৰ্শক বি খন 3/30/12/2011 তাৰিখে সম্পাদন হৈছিল আৰু প্ৰদৰ্শক বি খনত ₹1 ৰেভিনিউ টিকেট মৰা হৈছিল এক্সিবিট বি খন দিলীপ ঘোষৰ ঘৰত সম্পাদন হৈছিল এক্সিবিট বি খনত কাৰো সাক্ষী হিচাপে চহী লোৱা হোৱা নাছিল এইটো সত্য নহয় যে মোৰ সন্মুখতে 1,80,000 টকাৰ লেনদেন হোৱা নাছিল প্ৰদৰ্শক এ আৰু বি খন মোৰ সন্মুখত সম্পাদন হোৱা বুলি উল্লেখ নাই কোন তাৰিখে মই বাদীৰ লগত বিবাদীৰ ঘৰলৈ পইচা বিচাৰি গৈছিলো মোৰ মনত নাই এইটো সত্য নহয় যে মই বিবাদীৰ ঘৰলৈ পইচা বিচাৰি যোৱা নাছিলো এইটো সত্য নহয় যে এক্সিবিট এ এণ্ড বি খনত থকা চহীটো দিলীপ ঘোষৰ নহয় এইটো সত্য নহয় যে মই বাদীৰ লগত মিলিত হৈ ষড়যন্ত্ৰমূলকভাৱে এক্সিবিট এ আৰু বি খন তৈয়াৰ কৰিছো এইটো সত্য নহয় যে মই এক্সিবিট এ আৰু বি খন লিখা নাছিলো My lord,
Yes.
DW1, my lord. DW1 Propagos আর process examination মোৰ স্বামীৰ মৃত্যু 2/7/2012 তাৰিখে হৈছিল মানিক এন্টাৰপ্ৰাইজ দোকানখন মোৰ স্বামীৰ আছিল আৰু তেওঁ চলাইছিল তেওঁৰ জীৱিত কালত এই দোকানৰ সকলো লেনদেন মোৰ স্বামীয়ে কৰিছিল মোৰ স্বামীৰ জীৱিত কালত মই দোকানত আহিছিল মোৰ স্বামীৰ ঢুকুৱাৰ আগত অসুস্থ নাছিলে মৃত্যুৰ 3 মাহ আগত তেওঁ অসুস্থ হৈছিল আৰু মুম্বাইত চিকিৎসা চলাইছিল মোৰ স্বামীয়ে লিখা পঢ়া জানিছিল সত্য নহয় যে এক্সিবিট বি আৰু এক্সিবিট এ থকা চহী মোৰ স্বামী নহয় সত্য নহয় যে মোৰ নামত লিগেল নোটিছ ডেটেড 3/10/2012 খন পাইছিলো মোৰ এফিডেভিটত কি লিখা আছে মই নাজানো মই এই এফিডেভিট মই উকিলৰ সন্মুখত আদালত চহী কৰিছো ৰঞ্জন ডেকাৰ মোৰ দোকানত 10 বছৰৰ পৰা কাম কৰি আছে তেওঁ মোৰ দোকানৰ কৰ্মচাৰীৰ বাবে মই সাক্ষী হিচাপে আনিছো মোৰ দোকানখন বাচনৰ দোকান যাৰ পৰা বাচনৰ মাল আনো কুদ্দুস তেওঁক সাক্ষী মান্য কৰা নাই মাহে প্ৰায় ₹50,000 মান টকাৰ বস্তু লাগে আমি একে মানুহৰ পৰাই মাল বস্তু আনো মাল আনিব লগা থাকিলে কেতিয়াবা ক্ৰেডিটত আনো হোৱা কিন্তু সন্ধ্যা পইচা দিওঁ মোৰ ল'ৰা মানিক ঘোষ দেউতাকৰ জীৱিত কালত বিজনেছত ব্যস্ত নাছিলে আৰু মই ঘৰুৱা কামত বেছিকৈ ব্যস্ত আছিলো দোকানলৈ যাওঁ সত্য নহয় যে মোৰ স্বামীয়ে ব্যৱসায় বৃদ্ধিৰ বাবে বাদীৰ পৰা এবাৰ ₹40,000 আৰু এবাৰ 1,40,000 ধাৰত লয় সত্য নহয় যে মোৰ স্বামীৰ চিকিৎসাত টকা খৰচ হোৱাৰ বাবে উক্ত টকা ঘূৰাই দিব পৰা নাই আৰু আজি মিছা সাক্ষী দিছো মোৰ স্বামী ঢুকুৱাৰ সময়ত মোৰ ল'ৰাৰ 17-18 বছৰ আৰু ছোৱালীজনীৰ 9 বছৰ আছিল মুম্বাইত থকা অৱস্থাত আমাৰ 80,000 মান টকা খৰচ এই টকা মোৰ দেৱৰে দিছে কিন্তু উক্ত কথা জবাবত লিখা নাই মই মোৰ স্বামীৰ চহী এক্সিবিট এ আৰু এক্সিবিট বি কোনো পৰীক্ষাৰ বাবে উঠোৱা নাই DW2 ৰঞ্জন ডেকা মই লেট দিলীপ ঘোষৰ দোকানত আজি 10 বছৰ ধৰি কাম আছো কিন্তু এই কথা মোৰ এফিডেভিটত লিখা নাই দোকানখন বাচনৰ দোকান প্ৰায় 25-30 জন কাষ্টমাৰ দোকানত দৈনিক আহে মই কেতিয়াবা দোকানত নহাকে আছো মই দোকানত নথকাৰ অৱস্থাত যদি বাদী আহিছে আৰু কিবা লেনদেন কৰিছে মই গম নাপাওঁ মই 30/12/11 আৰু 1/5/2012 তাৰিখে দোকানত আছিল কিন্তু মোৰ মনত নাই উক্ত দিনকেইটাত লেট দিলীপ ঘোষ আছিল আৰু একো ঘটনা হোৱা নাই মই উক্ত দোকানত কোন তাৰিখৰ পৰা কাম কৰিছো মনত নাই মই কোন তাৰিখে দোকানত অহা নাই আজি ক'ব নোৱাৰিম 2010 চনত দোকানত প্ৰায় 80,000 পৰা 90,000 মান টকাৰ বস্তু আছিল দিলীপ ঘোষে ইংলিছত চহী কৰিছিল সত্য নহয় যে এক্সিবিট আৰু এক্সিবিট বি থকা দিলীপ ঘোষৰ চহী তেওঁৰ নহয় তেওঁৰ হয় সত্য নহয় যে এক্সিবিট এ আৰু এক্সিবিট বি থকা দিলীপ ঘোষৰ চহী তেওঁৰ হয় কিন্তু এক্সিবিট এ খন আমাৰ দোকানৰ নোটপ্যাডৰ কাগজ এই ওচৰত মই নিজে সাক্ষী দিম বুলি কৈছো মই মোৰ এফিডেভিটত এক্সিবিট এ আৰু এক্সিবিট বি থকা দিলীপ ঘোষৰ চহীটো তেওঁৰ নহয় বুলি কোৱা নাই মই দোকানত থকাৰ সময়ত মাজে সময়ে বাহিৰলৈ ওলাই যাওঁ সত্য নহয় যে মই মৃত দিলীপ ঘোষ আৰু তেওঁৰ পত্নীৰ খাতিৰত আজি মিছা সাক্ষী দিছো আমাৰ দোকানৰ মাল বস্তু সত্যবাৰী আৰু গুৱাহাটীৰ পৰা আনো কেতিয়াবা মঙ্গলদৈৰ অজিত ঘোষৰ পৰা আনো DW3 অজিত ঘোষ লেট দিলীপ ঘোষ মোৰ লগত ব্যৱসায়ৰ সূত্ৰে প্ৰায় 20 বছৰৰ আগৰ চিনাকি বাদিক বৰ্তমান মই চিনি পাওঁ ঘোষৰৰ আগত চিনি পোৱা নাছিলো লেট দিলীপ ঘোষৰ লগত মোৰ দোকান আছিলে মই মোৰ দোকানত থাকিলে দিলীপ ঘোষৰ দোকানত কি হৈছে দেখা নাপাওঁ আমাৰ দোকানত কাস্টমাৰ থাকিলে আমি ব্যস্ত থাকো আৰু ইজন সিজনৰ দোকানলৈ অহা যোৱা নচলে দাখিল দিয়া হ্যান্ড নোটখন মৃত দিলীপ ঘোষে কি লিখিছে চহী কৰিছিলে মই কি লিখি চহী কৰিছিল মই নাজানো পিছত কয় মই হ্যান্ড নোটখন দেখিছো আৰু মৃত দিলীপ ঘোষে ইংলিছত চহী কৰিছে হ্যান্ড নোটখন কোন তাৰিখে সম্পাদন হৈছে তাৰ মোৰ দেখা মনত নাই উক্ত হ্যান্ড নোটখনত সাক্ষী হিচাপে মই ৰঞ্জন ডেকাৰ চহী দেখিছো বাকী মানুহৰ চহী মই দেখা নাই মই হ্যান্ড নোটখনত চহী কৰিছো কিন্তু এক্সিবিট এ আৰু এক্সিবিট বি মোৰ চহী দেখা নাই সত্য নহয় যে দিলীপ ঘোষ আৰু পৰিয়ালৰ লগত ভাল সম্পৰ্ক থকাৰ বাবে মই আজি মিছা সাক্ষী দিছো সত্য নহয় যে মই হ্যান্ড নোটখনৰ বিষয়ে একো নাজানো মই দিলীপ ঘোষৰ ব্যৱসায় সম্পৰ্কে প্ৰায় সকলো কথা জানো মই দিলীপ ঘোষৰ পৰা মাজে সময়ে টকা লওঁ আৰু কেতিয়াবা দিওঁ কিন্তু উক্ত খাতিৰত মই বৰ্তমানলৈ ৰক্ষা কৰিছো দিলীপ ঘোষৰ মৃত্যুৰ পিছতো ব্যৱসায়ত মই তেওঁৰ পৰিয়ালক সহায় কৰি আহিছো ৰঞ্জন ডেকাই সাক্ষী হিচাপে চহী কৰা মই আজি আদালত দেখা নাই my lord he has his evidence was not so credible or either in favor of the plaintiff or the defendants but the evidence of the DW2 my lord he has admitted some facts that he has seen the exhibit A and B and those are in the notepad of the shop and he has also not denied that the signature is not the signature of the Dilip Ghosh in the notepad and he also said that he knows the signature of the Dilip Ghosh who used to sign in English. Then my lord, PW1 and PW2, the learned appellate court has found contradiction so far the second place of transaction. When the PW1 has not mentioned the place of transaction, the appellate court has wrongly came to a conclusion that the PW1 and PW2 has contradicted with regard to the place of second transaction. This is absolutely, my lord, wrong finding, my lord, and that is a presumption without any facts, my lord. On presumption. So, my lord, the exhibit, both the hand notepad is in the shop, my lord, notepad, and signed by the deceased and by the independent witness who has written the both the notepad, both the my lord, payment of money, my lord, money receipt, my lord. So, my lord, my lord, the facts of paying the money and taking money has been proved, my lord. There is nothing about that, nothing doubt about that, my lord. And the appellate court, my lord, first appellate court has wrongly came to a conclusion that there is a contradiction. That is not, my lord. And the,
So in a money claim, how a money execution note, hand note is required to be proved. Do you have any judgment on that? How a money execution hand note, like exhibit A and B, what is the requirement under law to prove? Is there any judgment? Do you have any
my lord,
suggestion?
I have not collected no judgment on this, my lord, but I have some judgment on the point of taking presumption, my lord.
No,
presumption cannot
presumption
be-
is another thing. You may be correct. This finding of contradiction may not be correct.
My lord.
But when the money suit is based on a hand note,
My lord.
what is the requirement under the law insofar as proof of the execution of the hand note is concerned? Either party, are you having any judgment with you on that?
Presently, I have no such judgment with you, Lordship.
Presently means, then I'll deliver the judgment. When will you show it? After the judgment is delivered.
Lordship, I'm
Huh?
sorry, Lordship.
That's the only issue here. If the execution of the hand notes are proved, then suit has to be decreed. If there is a defect in execution, and if it is held that the execution of these hand notes have not been proved in accordance with law, then the suit has to be dismissed. That's the only point, and both of you said that you are not prepared on that. You are not prepared on the only point which
My
is
lord.
relevant here.
My lord, contradiction of the
Contradiction
the
is,
second
forget it.
case of,
Even
and
if there
there-
is no contradiction, unless the hand note is proved, the suit will be dismissed.
my lord,
So you convince the court that the exhibit A and B has been proved as per requirement of law. You show us that
my lord, I may be given some time, my lord.
sometime.
My
We
lord,
have heard the
my lord,
matter
another
now.
date may be fixed, my lord. I'll show this, I'll try it.
Find out at 2, we can continue. 1 hour time is there.
My lord,
Hmm?
my lord.
Lordship.
You also look up some
Yes,
judgment.
Lordship. Lordship.
If you cannot find, then we'll see.
Lordship.
That's the only point here.
My lord.
Who has said what is not important? There is a document. If this document is proved as per law, the execution contents are proved as per law, the suit has to be decreed. There's no question about it. If it is not proved as per law, the suit has to be dismissed. That's the only point here.
My lord.
We'll come at 2. You try to find out. What is your case, Chaudhary? Hmm? No, I'm not taking up now.
Yes.
What is your case?
Case, my lord, the petitioner has filed a probate, my lord,
Hmm.
and that and the respondents have filed their objection, and on the basis of the
Who
objection,
is the
my lord-
other side?
my lord, they have not appeared, my lord. We have taken steps by speed post, register post, as well as Dusty service, and they refuse to accept the Dusty notice also.
Right, we'll
More time, my lord. Both of us jointly search, my lord. Either against or favor. No judgment, my lord.
How much time you want?
My lord, Shraddha, 1 week, my lord, 1 week, my lord.
Heard Mr. A.R. Sigdal and the counsel appearing for the appellant. Also heard Mr. Zaid Hussain, learned counsel representing the respondents. First of, on the request of learned counsel for both the parties, this matter be listed again for
On
hearing. After
15th, on 15th, Lordship, I shall be out of station till 14th,
listed again on 15/11/2022 for hearing
Lordship.
as a fixed item. Yes.
My lord, here in this case, my lord, the petitioner's mother, my lord, the petitioner's mother had executed a will in favor of the petitioner, my lord. Petitioner number one is the, petitioner number two is the temple, my lord. And petitioner number one is the daughter of, is the daughter of the executant, my lord. My lord, during the proceeding, my lord, the petitioner had exhibited the will as well as death certificate of her mother as well as the will. Death certificate is exhibit 1 and the will is exhibit 2, my lord. And she also adduced 4 numbers of, my lord, witnesses, my lord, in her favor. And the opposite parties, they have adduced 2 numbers of witnesses, my lord. And my lord, there is the evidence of PW3. PW3 is the petition is the writer, my lord, of the will, my lord. His deposition, my lord. May I read, my lord?
First of all, what is this case? What is the appeal? What are the?
Yes, my lord.
question
Your
of
lordship
law?
may kindly see the judgment. Judgment I have annexed, my
No,
lord.
no, you take your seat. That's not the way to argue an appeal. We have to first see, this is a judgment of reversal.
Yes, my judgment, my lord, they have dismissed, my lord, the probate, my lord. The petitioner, your lordship may kindly see, I have annexed the judgment at
Ms.
page,
Chaudhary, you please
yes, ma'am.
take your seat. Let
Yes,
me
ma'am.
understand, because you are not giving me what is required. You have straight away gone into who is the witness and who is.
Yes, my
First,
lord.
tell the court what is this appeal, whether you have, is a reversal or affirmation, or what is the question of law involved? Nothing. You have just started on who is PW1 and PW4. This is not the way to. So the petitioner number 1 wanted a probate
Yes, my lord.
of a will.
Yes, my lord.
That is
And-
the last will of her mother.
Yes, my lord.
What is the name of the mother?
Mother is Mandudari, Mandadhari Shukla Das.
Then what has happened? The trial court has dismissed.
Yes, my lord.
That is the district judge.
On the, yes, my lord.
Where is the order?
Judgment is at page 18, my lord. Annexure C.
On what ground it has been dismissed?
It means it has been dismissed, my lord, on the ground that your lordship may kindly turn to page 25, para 20, my lord.
No, please tell me what is the ground.
On the ground, my lord, it has been presumed, my lord, that the deceased, my lord, executed the will on 2/4/2010 and she died the very next day. But that is not correct, my lord. Here it is stated that your lordship may kindly see, it is, my lord, reflected in this paragraph, my lord, that from the probate petition, it is appeared that the testatrix executed the will in question on 2/4/2010, and on the same day itself, the testatrix died. It is an utter surprise that the testatrix, after attending the office of notary public at Hailakandi town, executed the will and thereafter on the same day she died. Further, the date of death of testatrix as mentioned in the probate petition differs from the date of death as mentioned in Exhibit 1, death certificate, wherein the date of death of the testatrix has been mentioned as 25/1/2014. In the probate petition, the petition has mentioned the date of execution of will and the date of death of the testatrix as 2/4/2010. But the Exhibit 1 death certificate reveals that the testatrix died on 25/1/2014. My lord, the petition is very much in the record, my lord. There is nowhere mentioned that the deceased died on 2/4/2010, my lord.
All right, now let us see where is the service of notice.
Yes, my lord. Notice was issued on 6/1/2020, my lord.
So what are the grounds of challenge?
Grounds, my lord. Grounds are given at page 5, my lord. One of the grounds is that the learned court below rejected the signature and the evidence of the attesting witnesses merely because they did not state the place and time where the will was executed, though they clearly stated about the execution of the will in question. And at page and ground 6, my lord, further the learned court below has erroneously held that absence of the word the last will would make the will inoperative. This aspect is also required to be adjudicated by this honorable court. Since the last will is not written, it is only written as will, my lord. Only on these minor grounds, my lord, it was
So
rejected.
how many witnesses were examined by the petitioner,
My lord, 4, my lord.
including attesting witness?
Yes, my lord.
Attesting witness was PW?
PW 3, my lord. PW 3 and 4, my lord. And the probate, it was also verified by one of the witnesses. The verification also there, my lord, I have annexed.
Okay, so let us read the impugned judgment.
Yes, my lord.
Then we'll call
Page 18, my lord.
to come again.
The instant title suit has been instituted on the petition filed by Srimati Mandira Pal and another under section 276 of the Indian Succession Act for obtaining probate of the will executed by the deceased Mandadhari Shukla Das, wife of late Motilal Shukla Das of Hailakandi town. It is stated in the petition that on 2/4/2010, the deceased Mandadhari Shukla has executed a will in favor of the executor petitioner, bequeathing the property mentioned in the schedule of the will as well as in the present petition. It is very specifically mentioned that the property is to be bequeathed upon the petitioner number 2, that is the name of the temple, namely Sri Shiv Mandir, and empower the petitioner number 1 as caretaker and of half of the scheduled land, and the remaining half will be absolutely devolved upon the petitioner number 2 temple. It is further averred that the petition that the testatrix also affirm in her last will testament that 3/4 of the profit of the property will be enjoyed by the petitioner number 1 and her 2 sisters, that is opposite party number 1 and 2, and the rest 1/4 will be devolved in the name of the petitioner number 2. The testatrix, by executing the will, appointed the petitioner as executor thereof, and she executed the will in presence of attesting witnesses. The petitioners have stated that there is no other probate petition has been filed on pending in any court of law except this court. The cause of action of this petition has been arisen on 2/4/2010, the date of execution of the will and the date of death of the deceased. The opposite parties appeared in the suit and contested the same by filing written objection denying the execution of the will as well as its genuineness. It is averred by the opposite parties that the deceased Mandadhari Shukla Das was the owner of the plot of land as described in the petition, and after her death, her 3 daughters, the petitioner number 1 and the contesting opposite parties, have inherited the same, but the petitioner number 1, who is a very cunning and litigant person with intent to grab the will property by deceitful means, manufactured the will in question, and therefore the petitioners are not entitled to get the probate thereof. Upon the pleadings of the parties, the following issues have been framed. Is there any cause of action for the suit? Whether the will in question was executed by the deceased Mandadhari Shukla, and whether at the time of executing the will, she was in the fit state of mind and health to execute the will, and whether the will is a genuine or not. Whether the petitioners are entitled to get probate of the will in question, to what other reliefs the petitioners are entitled. The petition side in support of the case examined 4 PWs and exhibited the death certificate of the deceased by Exhibit 1 and the original will by Exhibit 2. On the other hand, the opposite parties also examined 2 witnesses in support in their case, heard arguments of the learned counsels of both the sides, and perused the record, decision and reasons thereof. Issue number 1. The petitioner has come up with the petition for granting probate of the will executed by the testatrix Mandadhari Paul, while the defendant side denied the same and contended that testatrix never executed any such will. The proposition of law is settled that the assertion of a fact by one and denial of the same by the other constitutes the cause of action of a suit. Here in the instant suit, since the petitioner has come up with the petition for probate after death of the testatrix, and the defendant side denied the execution of the will by testatrix in this court, is the opinion that there is cause of action for the suit, and accordingly, the issue is decided in affirmative and in favor of the petitioner. Issue number 2, 3, and 4. For the sake of convenience, these three issues have been taken up together for discussion and decision. The learned counsel for the petitioner has submitted that the petitioners, by adducing the evidence of attesting witnesses as well as by producing the original will, have successfully proved the due execution of the will, and hence the petitioners are entitled to the probate thereof. Per contra, the learned counsel of the opposite parties has submitted that the will was prepared after the death of the deceased only to grab the joint property, and in support of the same, the attention of this court has been drawn to the fact that probate petition was not verified either by the petitioner or by attesting witnesses as required by the law. It is further stated that the affixing of seal impression in the will as well as on the photograph affixed on the will clearly show that will was prepared collusively. It is also stated that nowhere in the petition the date of death of the deceased has been mentioned, and it is also not mentioned anywhere in the petition that whether the will is the last will of the deceased or not. Regarding verification, it is the fact that the petitioner has written a few words towards verification, but it was not signed by anybody. Section 280 of the Indian Succession Act reads as follows. 280, petition for probate, etc. to be signed and verified. The petition for probate or letters of administration shall in all cases be subscribed by the petitioner and his pleader, if any, and shall be verified by the petitioner in the following manner, namely, I, the petitioner in the above petition, declare that what is stated therein is true to the best of my information and relief. Section 281 of the Indian Succession Act 25 provides for verification of the petition for probate by one witness to the will, and section 281 reads as follows. Verification of petition for probate by one witness to will. Where the application is for probate, the petition shall be verified by at least one of the witnesses to the will. When procurable in the manner as or in the effect following, namely, I, one of the witnesses to be last will and testament of the testator mentioned in the above petition, declare that I was present and saw the said testatrix affix his signature or mark thereto, or the said testator acknowledge the writing annexed to the above petition to be his last will and testament in my presence. Here in the instant suit, though the petitioner has mentioned some words regarding verification at the bottom of the petition, but it was not signed by anybody. However, the petitioner submitted affidavit along with the petition stating that contents of the petition are true and the best of the knowledge and belief. At this juncture, I would like to refer the following case law. Biswajit Dhar versus Chinu Rai Dhar, 2021 SCC, online Guwahati 265. For what have been noted above, it becomes clear that the application for probate in the case at hand was not required to be supported by affidavit, and the fact that the application for probate in the present case was not supported by any affidavit could not have made the application for probate not maintainable in law. The similar view has also been taken by the Honorable Delhi High Court in Khemchandra versus State, 2010 SCC, online Delhi to 1998. Therefore, no non-verification of the petition for probate does not call for its dismissal at the threshold. Regarding submission of the learned counsel that the date of death of deceased is not mentioned in the petition, but on perusal of the petition for probate, it is found in page 3 that the date of death of deceased has been mentioned as 2/4/2010. In answer to the submission of the learned counsel that nowhere in the petition for probate, the petitioner has mentioned that the will in question is the last will of the deceased, but in page 2 of para 3, the petitioner has mentioned that the will in question is the last will of the deceased. The petitioner side examined 2 and 4, the attesting witnesses of the will, and petition and PW.
Can you call Ritisha to come here? Ritisha.
And PW3, the scribe thereof. the PWs 2 and 4 have not stated anything as to the place, time, etc., where the will was executed by the testatrix. They simply stated they are the attesting witnesses to the will. They have not stated anywhere as to whether the testatrix was present when the will was executed and whether testatrix put her signature on the will in their presence or not. In this being the position, the probability of signing the will by any other person as testatrix cannot be ruled out. Narmada Prasad versus Murari Lal, 2018 SCC. The Supreme Court in the case of Kalyan Singh versus Srimati Choti, 1991 SCC, has observed that a will is one of the most solemn documents known to law. The executant of the will cannot be called to deny the execution or to explain the circumstances in which it was executed. It is therefore essential that trustworthy and unimpeachable evidence should be produced before the court to establish genuineness and authenticity of the will. It must be stated that the factum of execution and validity of the will cannot be determined merely by considering the evidence produced by the propounder. In order to judge the credibility of witnesses and disengage the truth from falsehood, the court is not confined only to their testimony and demeanor. It would be open to the court to consider circumstances brought out in the evidence or which appear from the nature and contents of the documents itself. It would be also open to the court to look into the surrounding circumstances as well as inherent improbabilities of the case of reach of proper conclusion on the nature of the evidence adduced by the party. Further, the Supreme Court in the case of H. Venkatachalal Yangar versus B.N. Thimmajamba has observed that although the mode of proving a will did not ordinarily differ from proving any other document, nonetheless it requires an element of solemnity in the decision on the question as to whether the document propounded is proved at the last will and a testament of departed testator. Where there are suspicious circumstances, the onus would be on the propounder to explain them to the satisfaction of the court before the will could be accepted as genuine. Where there are suspicious circumstances, the court would naturally expect all legitimate suspicions should be completely removed before the document is accepted as the last will of the testator. These principles have been reiterated in the subsequent decisions of this court in Rani Purnima Devi versus Kumar Khagendra Narayan Dev and Srimati Indubala Bose versus Manindra Chandra Bose. The Supreme Court in the case of S.R. Srivasa versus Padmavathamma has held that when the execution of the will is surrounded by suspicious circumstances, it was necessary for the propounder to answer the same to remove the doubt. The Exhibit 1 will was prepared and executed by the testatrix before notary, namely Notary Public K. Chaudhary of Hailakandi Bar Association, but none of the witnesses has stated anything about the execution of the will before Notary Public. Further, in title page of Exhibit 2 will, the words deed of will and a Smornolipi have been written. It is something peculiar that the testatrix herself was not sure as to what type of document she was executing, whether it was a deed of will or Smornolipi. From the probate itself, it is appeared that the testatrix executed the will in question on 2/4/2010, and on the same day itself, the testatrix died. It is an utter surprise that the testatrix after
1 minute.
yes, madam.
Yes,
My lord, I'm reading page 25, my lord.
yes.
Para 21. In the probate itself, the petitioner has mentioned the date of execution of will and the date of death of the testatrix as 2/4/2010. But the exhibit 1 death certificate reveals that the testatrix died on 25/1/2014 after about 4 years of the date of death as mentioned in the petition seeking probate. Nowhere in the evidence the petitioner's side has mentioned the date of death of the deceased. The photograph of the testatrix as affixed on exhibit 2 will appear that it was affixed subsequently because the seal impression on the title page of the will differs from the seal impression put on the photograph. More so, the notary public before whom the will was executed was not examined by the petitioner in order to prove its genuineness, or any record was called for from the custody of the notary public to prove the same. The death certificate of the deceased has been submitted in the suit, is a laminated one, but it appears that someone had tried to remove the lamination, and the said conduct shows that it was done only to temper the date of death and to make it at par with the date of death mentioned in the probate petition. From the above, it appears that there are strong suspicion in the due execution of will, and the petitioners failed to remove the suspicion as per law. In view of the above discussion, it is held that the petition side has failed to prove the genuineness of the will. Accordingly, the issues are decided in negative and against the petitioners. Therefore, the petitioners are not entitled to get the probate of the will.
What is wrong in this judgment?
My lord, here your lordship may kindly see, will is very much available with the record, my lord. And
Give
death
me-
certificate
give
is
the
also
LCR.
there, my lord.
You please, death certificate and will, please flag mark it.
Like mark.
And also flag mark the plaint. We'll see. Huh? Give me. Yes, please. The petitioner is she has renounced world. Is a sannyasi.
No, my lord, her sister. She is a widow, my lord. The petitioner is a widow. She was the one who used to look after her mother, my lord.
So this does not say it is the last will and testament of the.
Yes, my last will, that word is not there, my lord.
Hmm.
But
The fact that it is a will is not mentioned anywhere.
it was written in by the, my lord, by advocate's clerk, my lord. So, and the lady was illiterate, so. Her, in the deposition of PW3, my lord, it clearly reflects that there may be some mistakes in writing. In his cross also he admitted, my lord.
Who are the two attesting witnesses? Can you give their name?
One is the, my lord, advocate's clerk. Another one is there, one independent witness, my lord. He, my lord, just known to
One
them,
is
my lord.
Santosh Nath, is it?
Yes, my lord.
Who is he?
He is just known to the petitioner, my lord.
Hmm. And the other is Uttam.
Other is, my lord, one is, and the number three, PW2, Muhammad Samsul Haq. And another is Uttam, PW4 is Uttam Devnath.
They have been examined.
Yes, my lord.
The death certificate says date of death is 25/1/2014.
Yes, my lord. She also, my lord, there in the deposition of the petitioner also, she stated her mother, the date of the death of her mother. Her statement is also there, my lord.
You have the plaint, copy of the plaint? You
Yes,
have a
my
copy?
lord.
Let us read the plaint.
And the petitioner is the daughter of the deceased Srimati Mandadhari Shukla Das, wife of late Motilal Shukla Das of Hailakandi town, ward number so and so. The petitioner is by religion Hindu, Indian by birth. During lifetime, the deceased Srimati Mandadhari Shukla Das, wife of late Motilal Shukla Das, has purchased the scheduled land. On 2/4/2010, deceased Srimati Mandadhari Shukla Das, wife of late Motilal Shukla Das, executed a will in favor of the executor petitioner and expressed her unequivocal will that the property mentioned in the schedule herein this petition will rest upon the petitioner number 2 after her death, and further affirmed that the petitioner number 1 shall be the caretaker of the half of the scheduled land, and the rest half will be absolutely owned by the petitioner number 2. That the deceased Mandadhari Shukla Das affirmed in her last testament that 3/4 of profit of the property will be enjoyed by the petitioner number 1 and her 2 sisters, opposite parties number 1 and 2, and the rest 1/4 will be donated in the name of the petitioner number 2. That the testator further expressed that the petitioner will be the executor of his will, and the witnesses duly attested the will of the testator. That necessary particulars as required under section 276 of the Indian Succession Act 1925 are given herein under. Date of death of the deceased. The will is the first and the last will of the deceased Srimati Mandadhari Shukla Das, wife of late Motilal Shukla Das. That the will was duly executed by the deceased and duly attested by the witnesses. The amounts of assets which are likely to come in favor of the petitioner number 2 is about 1 lakh only. The petitioner is the executor and the will was executed in their favor. There is no other kind except OPs of the present petition, and accordingly they are impleaded as party to this case. That no petition was preferred for grant of probate in favor of the petition number 2 before this court or any other court of law. That the cause of action of this petition has been arisen on 2/4/2010 and the date of execution of will, and on the date of death of Srimati Mandadhari Shukla, wife of late Motilal Shukla. That the deceased was permanent resident of the district and the properties mentioned in the schedule are within the Hailakandi district. As such, this petition is triable by this court. Under the circumstances, it is prayed that your honors would be pleased enough to grant probate in favor of the executor, petitioner number 2, for the properties mentioned in the will dated 2/4/2010, and further pray that your honor may allow the petitioner 1 to enjoy the property as per the terms and conditions of the last testament will, which exhibited by the deceased Mandadhari Shukla, executed has, and for this act of kindness, the executor petitioner shall ever pray.
So date of death is not mentioned.
Not mentioned, but the death certificate was furnished, my lord. She stated the cause of action is 2/4/2010, the date of execution of will, and the date of death of her mother, my lord. But although date is not mentioned here, my lord. But she did not say that on the very day her mother died, my lord, as it is reflected in the judgment, my lord.
Let us read her evidence, PW petitioner number 1.
Yes, ma'am.
Yes.
Yes. I am Mandira Pal, aged about 56 year, daughter of late Motilal Shukla Das, Hailakandi town, ward number so and so, by profession housewife, Indian, do hereby solemnly affirm and declare as follows: that I am the petitioner of the petition. My mother Mandadhari Shukla Das, wife of late Motilal Shukla Das, during her lifetime had purchased the scheduled land mentioned in the petition. On 2/4/2010, my mother Mandadhari Shukla Das executed a will in favor of the executor petitioner and expressed her unequivocal will that the property mentioned in the schedule of the petition will rest upon the petitioner number 2 after her death, and further affirmed that I will be the caretaker of half of the schedule and the rest of half will be absolutely owned by the petitioner number 2. That the deceased Mandadhari Shukla affirmed in her last testament that I, along with my 2 sisters, opposite party number 1 and 2, will enjoy 3/4 share of the profit of the property, and the rest 1/4 will be donated in the name of the petitioner number 2. The testator further expressed that the petitioner will be the executor of the will. The witnesses duly attested the will of the testator. That necessary particular as required fewer than 276 of the Indian Succession Act 1925 are given in my petition. The will was duly executed by the deceased and duly attested by the witnesses. There is no other kind except OPs of the petition, and accordingly they are impleaded as party to this case, and no petition was preferred for grant of probate in favor of the petition number 2 before this court or any other court of law. I filed this petition for granting probate in favor of the executor, petition number 2, for the properties mentioned in the will dated 2/4/2010, and further for allowing me to enjoy the property as per the terms and conditions of the last testament will, which executed by the deceased Mandadhari Shukla Das. Exhibit 1 is the death certificate of Mandadhari Shukla Das. Exhibit 2 is the will dated 2/4/2010, which executed by the deceased Mandadhari Shukla. Exhibit 2(1), 2(2), 2(3) are the signatures of the deceased Mandadhari Shukla Das. Exhibit 242526 are the signature of attesting witness Uttam Devdas. Exhibit 272829 are the signature of attesting witness Sri Santosh Nath. Exhibit 210, 211, 212 are the signatures of the writer of the will. The statements made above are true to the best of my knowledge and belief, and I sign and sworn in the same remaining present before the Sirestadar of this honorable court on this 22nd day of March 2016.
So let's go to the cross.
Cross, my lord. On 25/1/2014, my mother died, and accordingly I have submitted death certificate of my mother. It is not mentioned in the will in question or in my evidence that the will in question was the last will of my mother. It is not mentioned in the will in question that the same was executed without any pressure. It is not mentioned in the will that how much my mother was aged at the time of performing the will. The will in question is also a Saran Lipi. It is not mentioned in the will that the same was executed by my mother in presence of any witness. Anil Pal, Mohan Das, Adhir Das are my neighbors. Sriman Dev is the grandson of the testator of the will. Gauri Pal, Mintu Pal, Sumo Pal are the granddaughters of Mandodari Shukla Das, and Maya Rani and Mangala Shukla are the daughters of the testator. But no one out of the above person is the witness of the will. Till date, I have not submitted the original of the will.
Let us read the next.
Next is PW2.
There is further cross of PW1.
Yes, my lord. At the starting of the name Srimati is used against the name of women, and Sri is used at the starting of the name male person. Accordingly, in the will, at the starting of our names, including testators, Srimati is there. But in the will, testator Mandadhari Shukla put Sri at the beginning of her name instead of Srimati. Mandadhari Shukla put her signature by putting Sri at the starting of her name differently in the respective pages of the will. It is not a fact that the name of Mandadhari Shukla was written differently. It is not a fact that Mandadhari Shukla did not execute the will in question, and as such, there appears the alleged signatures of Mandadhari Shukla in different style in the alleged will. Opposite parties filed a criminal case against me for making alleged false will. My address was printed wrongly. It is not a fact that the address of Mandadhari Shukla was printed wrongly. In the will, there are impressions, 2 numbers of seal. It is not a fact that fraudulently, subsequently, I pasted the photo of testator and put the seal. Saran Lipi and will are different documents. In the will, it is written that the same is will as well as Saran Lipi. I have not filed this case for not execution of any Saran Lipi. It is not a fact that there is no seal and signature of the seller of the stamp wherein the will was prepared. It is not a fact that will in question was prepared collusively. It is not a fact that I have hired the witnesses of this case. The next is PW2, my lord. That the petitioner is the daughter of the deceased Srimati Mandadhari Shukla Das, wife of late Motilal Shukla Das of Hailakandi town, ward number so and so. The petitioner is by religion Hindu, Indian by birth. During lifetime, the deceased Srimati Mandadhari Shukla Das, wife of late Motilal Shukla Das, has purchased the scheduled land. On 2/4/2010, deceased Srimati Mandadhari Shukla Das, wife of late Motilal Shukla Das, executed a will in favor of the executor, petitioner, and expressed her unequivocal will that the property mentioned in the schedule herein this petition will rest upon the petitioner number 2 after her death, and further affirm that the petitioner number 1 shall be the caretaker of half of the scheduled land and the rest half will be absolutely owned by the petitioner number 2. Deceased Mandadhari Shukla Das affirmed in her last testament that 3/4 profit of the property will be enjoyed by the petitioner number 1 and her 2 sisters, opposite parties 1 and 2, and the rest 1/4 will be donated in the name of petitioner number 2. The testator further expressed that the petitioner will be the executor of his will and witnesses duly attested the will of the testator, and I am one of the witnesses to the will. Exhibit 2 is the will dated 2/4/2010, which executed by the deceased Mandodari Shukla Das. Exhibit 21, 22, 23 are the signature of the deceased Mandodari Shukla Das. Exhibit 24, 25, 26 are the signature of attesting witness Uttam Devdas. Exhibit 27, 28, 29 are the signature of attesting witness. Exhibit 210, 211, 212 are the signature of the writer of the will. The statements made in the above are true to the best of my knowledge and belief, and I sign and sworn the same, remaining present before the Sirestadar on 22nd March 2016. In the cross, I cannot say as to whether there are double seals in the front page of the will in question. I also cannot say as to who put signatures in 3 different types in the will. I put my signatures as attesting witnesses in the will. I cannot say the contents of the will in question. I cannot say whether any case was lodged against me by opposite party Mangala Shukla Das. My house is situated at a distance of about 12 miles away from the house of Mandadhari. I am not blood related relation to Mandadhari. I am in no way connected with Mandira. I do not participate in any bichar in the house of Mandira. I do not know whether there is any dispute regarding Mandir of the house of Mandadhari. The local people adjudicate the dispute in if any, between the parties. I have forgotten whether I submitted written evidence or not in the court. I can say the year of the execution of the concerned will, but I cannot say the date specifically. I do not know whether Mandira Pal prepared any document or she submitted the same before the court. I do not know whether Mandira Pal stolen away all the documents of Mandadhari. I do not know if any dispute is going on in this respect. In the year 2014, Mandadhari Pal expires due to old age ailments. It is not a fact that I have deposed falsely, being influenced by Mandira Pal. Then there is my lord PW3, my lord. Samsul Haq, the petitioner is the daughter of Srimati Mandadhari Shukla. This portion, my lord. May I read the cross, my lord? That I wrote the will in question. I am the advocate's clerk, and at that time I was the president of Advocate Clerks Association, Hailakandi. There is another deed writer association. It is not a fact that I do not have any license to write will, etc. If any mistake is occurred in the contents of any will or documents, in that event, a note should be made under the contents of the will or documents. In the heading of the will, there is printing mistake in respect of the address of the parties. It appears in the will that there are 2 seal impression at the same place. It is not a fact that exhibit 2.1, 2.2 and 2.3 were written in different style. Will and Saranlipi are different documents. In the will in question, there is written that it is will and Saranlipi. The instant case is for the execution of will. Regarding the mistake, I did not make any note in the will, as at the time it did not come to my notice while I put signature therein, as I was busy in my other works. It is not a fact that the addresses of the attesting witnesses are not mentioned in the will. In the backside of the stamp of the will, there is no sealed signature of the Treasury Authority. The witnesses reside far away from the village of the testator. The daughters of the testator are not witnesses in the will. I cannot say as to whether the witnesses are the relatives of the testator or not. It is not a fact that will in question is not genuine. I do not have any knowledge about the filing of the criminal case against the petitioner of the instant case. It is not a fact that to grab the entire land of the will in question, the alleged will was prepared collusively. It is not a fact that I have deposed falsely. So, my lord, the advocate's clerk, he admitted that there are some mistakes, but he was unable to correct because he was busy with some other works. So, my lord, this is my submission, my lord.
All right. All- What is this petitioner number 2? There is no such legal entity as
My lord, the temple, my lord.
temple is not a legal entity.
Here, my lord, they have made the party, my lord, as the temple as the petitioner number 2, and the petitioner number 1 is he is the daughter, that is the caretaker of the temple.
Temple is a juristic person.
Yes, my lord.
Sure. Can you show me some judgment on that?
My lord, here in this petition, my lord, the
No,
temple has.
petition, whatever,
Yes, my
petition, whatever is written is not binding on the court. Are you saying whatever the petition writer has written is binding on the court?
No, no, my lord.
What is the correct legal position?
My lord, the petitioner, my lord, who is representing it should have been the petitioner. And the petitioner is representing the temple also, my lord. And in fact, my lord, testator, she had donated the land in the name of the temple, my lord. So, my lord, temple may also be considered as.
She is the executor of the will.
Yes, my
That is
lord.
mentioned in the will.
Yes, my
Is
lord.
that mentioned in the will? Where?
Will is there, my lord. It is in
Can you
Bengali,
point
my
out
lord.
where it is mentioned? It's also-
Yes. Will is in the record, my lord.
So take down, I heard Ms. S.B. Chaudhary, learned counsel appearing for the petitioner. The respondents have not appeared.
Yes, my lord, it is here, my lord.
Service of notice. Arguments concluded, judgment reserved. What is that?
Will, my lord, it is written in Bengali, my lord. May I read, my lord?
No. Is it?
Yes, my lord, it is
mentioned that
reflected.
she is the executor.
Yes, it is reflected, my lord. Obliged, my lord.
Hearing list, letter item 3 and 4.
All item 1.
One minute. Thirty, I have mentioned
We'll call item 1.
Item 1. Item 1.
one.
Yes, Mr. Sanchez,
Here,
what is the
here
matter?
in this case, my lord, a simple question has involved. That was this, my father expired.
After the death of my father, I have filed a death certificate before the executing court, my lord. Now the executing court did not rely on the death certificate because the serial number was different, because it was the computerized copy. So two different serial number was given. That's why the trial court stated that no, it is not the authenticated document, so I shall not accept it. What was the case, my lord? That the plaintiff, he has filed a suit against my father as well as one of the co-owner on Thanbal Singhi and another one, KD Chajer. Thanbal Singhi was expired before filing of the suit. He was already expired. That was also within the knowledge of the court. But legal acts have not been brought on the record. My father was at that time alive, and notice someone was issued, but that was issued at the Nagaon address, though my father was residing in Surat. So the notice was, how that was stated, I do not know, my lord, but an ex parte order was passed against my father. And accordingly, the suit was proceeded. Only one respondent contested, my lord. So a decree, ex parte decree was passed against me. So when the plaintiff has filed an execution case to execute the decree, I came to know about that, and I filed that application before the court. That was that your lordships may come to that applications which has been filed by me before the executing court, my lord. That is
execution proceeding is stayed.
state, state, my lord. And there is also, my lord, one appeal is filed by the respondent number 1, who is contesting the suit since beginning. So that was also pending. But since the appellate court has not granted the stay, so the execution case was put, so the decree was put in execution. And when I came, that yes, the decree also passed against my father, who was died long back. That's why I filed the application before the court. That is, since the decree is itself nullity, that cannot be passed against a dead person. That was the issue raised by me before the executing court.
Where is the order?
There are 2 orders I am challenging before this honorable court. That first order is at page 22. Passed on 20/12/13. Though today order was to be passed, but the same has to be deferred in view of the petition number 167/13 filed by Santilal Duggar under section 138 of the evidence, praying for re-examination himself to clarify about the serial numbers appearing in the death certificate of his father. Having perused the petition and the death certificate produced by this petitioner in respect of death of his father, it is found that the ground shown for re-examination is divide of marriage. The petitioner, having detected his own fault, has sought the present petition to cover up the anomaly. Same, needless to say, cost be granted, as the petitioner was accorded enough opportunity earlier. Accordingly, petition number 167/13 is rejected with cost of rupees 1,000. That was regarding my re-examination. Now the order which has been passed finally at page 25. At page 25, another order was passed on 7/1/2014. That was the relevant. I'm reading, my lord. The present order relates to petition number 39/13 filed by petitioner Santilal Duggar, claiming that the decree in TS number 82/06 is a nullity in itself because the decree was obtained against a dead person. The petitioner claimed the defendant number 2, namely Bhavanlal Duggar, was his father. He expired on 4/3/09 at Surat, Gujarat. The petitioner produced a copy issued by Surat Municipal Corporation, which is a death certificate, and made it Annexure 1.
In petition number 3913, the petitioner also adduced evidence and he was duly cross-examined by the decree holder. During cross-examination, Santilal Dugar admitted that annexion 1 can be created also. He also admitted that the fact of the death of his father was not mentioned by K.D. Sajer, who gave reply in the main title suit. Having regards to annexure 1, it came out clearly that the issue number in annexure 1 is shown as 0062448, wherein the issue number in exhibit 1, which is proved in original, so that issue number as 0062449. Now annexure 1 and exhibit 1, which were relied on by the petitioner, show two different issues number. This creates doubt regarding the authenticity of the death certificate purported to be issued by Surat Municipal Corporation. Further, it was the bounden duty of the petitioner to have intimated the court in TS number 82 of 06 regarding the death of the defendant number 2. As it shows from the evidence of the petitioner, his petition that he was well acquainted with the facts of TS 82 of 06. It also reveals that by filing the present petition, the petitioner is delaying the execution proceeding. Considering evidence and the anomaly detected in the very death certificate, the prayer of the petitioner is to nullify the decree passed in TS number so-and-so is rejected with the cost of rupees 5,000. So that was the order, because I have produced a death certificate, but court stated that since the issue number, serial number are different, so that is not an authenticated document. Death is not denied. That was admitted. Yes, he has expired. Regarding only the serial number, because whenever you obtain a computerized copy from the computer, issue number, serial number changes. So first I annex one annexer, thereafter exhibited. In exhibit, I given the death certificate of another issue. So the court did not rely upon this death certificate. That's why I filed an application under section 138 of the Evidentiary Act for re-examination myself, that I shall clarify why there was a difference. But the court did not allow me for re-examination. So my submission before the court that since the decree is nullity, cannot be passed against a dead persons, that is liable to be set aside.
Father of the petitioner was the defendant number 2.
Yes, madam. Yes.
In a suit filed by the respondent.
Yes, my lord.
And what is the suit for?
Suit for declaration of right, title, and interest in respect of 1 katta 6 acres of land at Nagaon town. He has filed. This money land was purchased by me, and I was one of the co-owner. But since I did not get the opportunity to contest, I could not appear. Now, one of them, this respondent number 1, that the defendant number 1 who was contesting, and he has also filed the appeal, and the appeal is pending. So when I have pointed out this fact in the execution proceeding, it was the duty of the decree holder, also appellant, since the appeal is pending, to file an application for substitution of the legal heirs of defendant number 2, since I have made the appearance. That was also not done, my lord. And moreover, interestingly, my lord, one Thanmal Dugar, who is the respondent here in this case, he died long before filing of the suit. That was also there. But the court did not substitute the legal heirs. At this point was raised by me in the executing court in my petition. And if your lordships may come to my petition, that is page 14, and relevant para is, my lord, 15, my lord. So I am reading, my lord, some important point raised by me before the executing court at page 15, my lord. First, my lord, reading, my lord, para 3. that subsequently petitioner father died on 4/3/2009 at Surat in Gujarat, but neither the petitioner nor the other heirs were heard as a party in the suit, and the suit proceeded as such against the dead person of the petitioner, and the same was decreed. Next, my lord. Thus, recently the petitioner came to know about the filing of adjudication case, and our inquiry came to know about the facts that decree was passed against his father on 29/10/11, although he died on 4/3/2009. Thereafter, the decree holder filed this adjudication case against the father of the petitioner, although he is dead. That the petitioner said the decree passed in the suit is a nullity in as much as neither the heirs of the Thanbal Surana were heard as a party in the suit, nor the legal heir of Banwarela Duggar, including the petitioner, was substituted. And as the decree cannot be executed as the decree passed against the dead person is nullity. This Thanbal Duggar was expired before filing of the suit. So this point I have my raise. A decree holder was also there. Appeal was also pending. So he could have filed the application process of legal errors that was there, my lord. So the executing court, my lord, committed a illegality, and that's why, my lord, I have come before your lordships, that merely basing that serial number was different, the court did not consider my death certificate, and authentication was also challenged by the this trial court, that cannot be acted upon, my lord. So the computer is copy, my lord, the death certificate. Even death is not disputed, my lord. Only serial number. So this is illegality committed by the trial court, my lord. That's why I have come with a prayer that the order passed by the trial court, both the orders may be set aside, my lord.
Other side has not appeared.
He did not appear, my lord. He did not come, my lord. Though his name has been shown in the cause list.
Who is appearing for the other side?
Other side appearing in the case, my lord. One Deori, my lord. S. Khan and Mr. M. Deori. His name has already been shown, my lord. This case is coming again and again, man. So many times this case has come before the honorable court, my lord.
Achha, you take down. Heard Mr. R.C. Sancheti, learned counsel appearing for the petitioner. None has appeared for the respondents. For the respondent. Full stop. In this revision petition, 2 orders passed by the learned Munsif number 1, Nagaon in connection with title execution case number 1/2012. That is the order dated 2012-2013 and the order dated 7/1/2014 have been put under challenge. The facts of the case, in a nutshell, are as follows. Full stop. The respondent herein as plaintiff had instituted title suit number 82/2006 in the court of learned Munsif number 1, Nagaon, praying for a decree declaring his right title interest over the suit land, and also for issuing a decree of permanent injunction. In the aforesaid suit, in the aforesaid suit, what is the name of defendant number 1?
One, my lord, this K.D. Chajer, my lord.
You have not made him a party here, is it?
My lord, Kandidan Chajer, my lord, he's the respondent, my lord, who is contesting his case on. So I am not concerned with him.
You are actually, I should have dismissed the petition on that. He is a pro forma respondent. He is concerned or not concerned, let him say. What is his name? Give it in writing.
Because my lord, the plaintiff, only one the plaintiff, he is not contesting. He has not filed any.
What is the name of the defendant number 1?
Defendant number 1, my lord, this Kandidan Chajer. Kandidan Chajer.
Can you write the name in a paper?
Kandidan Sajari.
Once so and so has been included as
Kandidan Sajari.
defendant number one. Whereas the late father of the petitioner.
Because he did not give any
Banwari-
objection.
Banwarlal Dugar.
Yes,
Hanwarlal Dugar was implemented as the defendant number two. Full stop. The suit filed by the respondent as plaintiff was decreed on contest by judgment dated 29/10/2011, passed by the trial court. Full stop. The defendant number one, who had contested the suit, had challenged the judgment and decree passed by the learned trial court by filing an appeal which is pending disposal. System. However, since no stay order was passed by the first appellate court, the decree dated 29/10/2011 was put to execution in title execution number in title execution case number 1 of the 2012. First up. Although the defendant number 2 did not contest the suit, his son, that is the present petitioner, had subsequently filed an application before the executing court along with copies of the death certificate issued by the Surat Municipal Corporation, showing that the father of the petitioner, that is Shantilal Dugar, had died.
Bhavanlal Dugar, my lord.
Sorry, Bhavanlal Dugar had died on
4/3.
4/3/2009 in Surat, in the state of Gujarat. Full stop. The basic contention of the petitioner before the executing court was to the effect that the decree dated 29/10/2011 having been passed against a dead person, the same was a nullity in the eye of law. Full stop. In support of his above contention, the petitioner had examined himself as a witness and exhibited 2 certificates issued by the Surat Municipal Corporation. However, taking note of the fact that the 2 certificates produced as Annexure 1 and Exhibit 1 carried different serial numbers, the learned court below had not only rejected the same by order dated 7/1/2014, but had also declined the request made by the petitioner to re-examine himself so as to explain the discrepancy by the impugned order dated 20/12/2013. Hence this revision petition. Mr. Sancheti submits that the difference in the serial number in Annexures 1 and Exhibit 1 had arisen due to the fact that the certificate exhibit Annexure 1 proved in original contained a issue number pertaining to the record of the municipal corporation, whereas exhibit 1
One, my lord.
was a computer generated
Yes, my lord.
certificate.
Yes, my lord.
Hence the discrepancy in the serial, hence the discrepancy in the issue number. First up, Mr. Sancheti further submits that the discrepancy could have easily been explained by the petitioner if he was re-examined in terms of the prayer made by White petition number 167/2013, which was rejected by order dated 20/12/2013. Yes. Full stop. After a careful scrutiny of the order dated 7/1/2014, I find that the learned executing court did not come to a conclusion that the deceased father of the petitioner did not suffer death on 4/3/2009, but the controversy is limited to these issue numbers appearing in the two documents issued by the Surat Municipal Board, both
Yes,
testifying-
corporation.
the Surat Municipal Corporations, both certifying the date of death of late Bhanwarlal Dugar. Full stop. If Bhanwarlal Dugar, who was the defendant number 2 in the title suit, had in fact died on 4/3/2009, that is prior to passing the judgment and decree dated 29/10/2011, and if the decree would affect the right of Bhanwarlal Dugar and or his legal heirs, then it is evident that there was a duty upon the plaintiff to substitute the legal heirs of Bhanwarlal Dugar in as much as a decree passed against a dead person without substituting his legal heirs would undoubtedly be a nullity in the eye of law. First of all. Therefore, the core question that would have to be determined in this case is as to whether the decree in this case has been passed against a dead person and not whether the serial issue numbers of the death certificates and not now, has to be determined as so and so has been passed against a dead person. First up, in determining the said question, what would be relevant is the fact as to whether cogent evidence is available before the court to come to a conclusion as regards the date of death of the person, and not as to whether the certificate, whether the serial issue number appearing in the certificate is acceptable or not. First up. Since the petitioner has categorically taken a plea to the effect that his father had expired before the decree was passed, the said aspect of the matter will have to be determined by the executing court before proceeding further in the matter. First of all, however, as noticed above, the aforesaid issue has not been determined by the learned executing court on the basis of the petitions numbers 167/2013 and 39/2013 filed by the petitioner. First of all, this court is therefore of the opinion that the impugned orders dated 20/12/2013 and 7/1/2014 suffers from error in exercise of jurisdiction and calls for rectification by this court. First of all, the impugned orders are accordingly set aside. The learned executing court is directed to decide the issue, decide the question of issue is directed to decide as to whether the defendant number 2 entitled suit number so and so, CFE number 2. That is Bhanwarilal Dugar did in fact die before the decree was passed. And if so, the impact of the same. And if so, what would be the impact of his death on the impugned decree? Full stop. The aforesaid aspect of the matter we decided by giving an opportunity to both the sides to present their case. Be decided as expeditiously as possible, preferably within a period of 3 months from the date of receipt of a certified copy of this order, after giving both the sides adequate opportunity to present their case. The revision petition stands disposed of accordingly. Send back the LCR.
Well, may I please also? Right, in item number 4, the respondent died on 1st of November, Lordship, when the matter came up, we came to know. Well, we have filed an application for substitution of the legal heirs of the respondent, along with an application for setting aside abatement and the condonation of delay.
When did you file?
We've today filed, Malad. The officer from Dibrugarh, he has come today, Malad. We could file it today only, Malad. Malad, since my friend, he was appearing earlier for the respondent, and he is also appearing for in the other matter, Malad. In the other matter, the deceased respondent was a director. I have given him a copy for his knowledge, Malad. Malad, kindly take up our IAs and take up the matter on Monday, Malad. Or tomorrow, or if Lordship permits, Malad.
Lordship, I have no difficulty with that, but I am not holding the brief. If it can be taken up after 1 week, I will have a wakalat number that will be proper.
On the request of Mr. D. Nath, learned counsel for the petitioner, public state of Assam, appearing in both these matters. These cases again after a week by tagging the IA.
I have the filing numbers only, Malad.
Under filing numbers, give the filing number. Filed in CRP IO number.
CRP IO number 46 of 2014.
46 of 2014. First of a copy of the IA be furnished to Mr. G. Kandelia and its counsel for the respondent appearing in both these matters. Is the cases accordingly? Yes.
I am for in item number 5, my lord. Let it be in the list. I have also not prepared this matter, my.
You
I am
have,
for the respondent, my. In item number 5,
you have for the respondent.
I am for the respondent. Otherwise,
What about the other side?
my lord, government has not prepared this. M. Dakau was there, my lord.
He's not around.
My lord. So let it be in the list, my lord. Next week I will. All right.
Any matter, both sides are ready.
But just for a clarification, Malad, this matter will remain in the part 2 list, Malad.
No, it will be listed again.
Doctor.